of the Zoning Board of Appeals to order for June the 23rd at 7:36. Would you all rise for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, just some procedural matters to get underway before we go. We're going to go out of order with respect to a couple of different hearings tonight because some might take longer than others. So based on my assessment of what we have on the docket tonight, I'm going to call a few matters out of order. Procedurally, I do want to, as it relates to any applications that may be continued to the next regular meeting, and as it relates to board appointments, it's my understanding in a communication from the Selectman's office today that Doug, effective next month, well, you're being elevated to a regular member, okay, with the new appointment schedule in August. So I think that means you're still an associate for tonight, but going forward, so congratulations for that.
Welcome to the island.
So,
Oh,
my understanding is that does, however, create two associate vacancies going forward. It's my understanding that I was also reappointed. Rick and Mr. Byers.
Did you not know that until you got the email?
I did not know that until I got the email. But regrettably, and just for the purpose of the record, regrettably, Mr. Byers did not seek reappointment, so I think this would be his last official meeting with us.
oh.
And I'd like the record to reflect his noteworthy service to the town and to the board, and also that of Mr. Laporto, who has been with us for an equally as long time. He also is not seeking reappointment. So as it relates to a 5-member board and how the board is comprised going forward, most of the all of the applications here tonight require supermajorities. They would require 4 votes for approval. So as long as you want to understand who the regular members are tonight and who they would be going forward if there's another meeting. That being said, next on the agenda would be the acceptance of minutes.
I'll make a motion to accept the minutes from May 12, 2015 as written.
I'll second the motion.
Motion and second. Any discussion? Hearing none. All in favor?
Aye.
Minutes are approved. Committee reports. Do we have a report from the Housing Partnership Committee? Ms.
So that means that, no, I do not.
Okay.
So that, does that mean that, are you going to be still on the Merrimack Valley?
Yes.
Okay.
I'm still the,
Would you send us a correspondent?
I will, yes, yes.
Thank you.
Monthly?
Monthly, yeah. I'll come to the meetings just to
you.
do the report. Yes.
Yeah.
Thank you, Mr. Byers.
Yeah. Don't hold me to that.
Is there a report from the Merrimack Valley?
We don't meet in June, July, or August.
Okay.
But I will continue to correspond as I have, and same thing with planning board and any correspondence that is, relevant. We continue to have our, I think some of the members did the citizens planning training program that they offer for members, and so whenever I get that stuff, I'll forward it to Angela as well. So I'll keep you posted on anything happening there that would affect the planning and zoning boards.
Okay. Well, thank you very much. Sure. All right, so I'm going to skip down to discussion items, which is a notice requesting an extension from a special permit by Mr. Smolak. I was looking through the decision, and I don't remember the particulars, but I noticed that I had recused from the decision when it had issued. I don't really remember why, but I think as it relates to the decision, your extension, I am also going to recuse from that hearing and pass the gavel over to Ms. McIntyre so she can hear that for you. Okay?
And so you could hear me too.
Okay. Mr.
Yeah, and I also, after that hearing, got involved professionally, so I'm going to just step out on the extension. We've already talked.
I understand. So thank you.
So Al and I are going to go have coffee.
You might as well keep walking.
So, Brian Vaughn, on behalf of the applicant, 288 Sutton Street LLC. Steve Smolak is the principal. Steve's with us if you have any questions tonight, but you may recall this matter, or some of you may not having been involved with the zoning board at the time. It's a 5-lot subdivision off of Sutton Street, and we're just coming up against the 2-year period for special permits. The subdivision was approved as 5 separate lots, with a duplex on each of the individual lots. So there were 5 separate special permits approving the individual duplexes. Primarily, the reason for delay, I should mention it, and it was outlined in my partner's letter to the board, that there has been some substantial work that has been done on the project, just not on the individual lots within the subdivision. And it's been mostly work that's been done out on Sutton Street to provide necessary utility work and access to what's going to be the subdivision roadway coming into the subdivision. But going back to when this was originally approved, part of the delay was really dealing with the economic climate at the time, and it wasn't really the time for a developer to be digging and getting into the ground and getting in too deep into a project. And another issue that just came up was Mr. Smolak was approached by another developer who was seeking to purchase the permits and project from him, and so there were some discussions that went on over a period of time, and Steve decided to proceed with the project himself. But the good news is that we've come along. Steve's got his planning board and Concom approvals as of today, and he's ready to really move forward with the project. So we're just seeking an extension on the special permits for the individual lots within the subdivision.
I'm sorry, you haven't touched any of the lots yet? Not one lot? You haven't dug anything, nothing?
Not on the lots within the subdivision, because there wasn't an existing roadway. So before we improve the lots, we're really going to get the subdivision roadway installed.
Sorry, Alan.
My question was going to be, for how long are you requesting an extension for?
I think it was just a 1-year period that we were requesting the extension.
You can only do it once?
I'm asking you,
Yeah.
I don't know.
Yeah, you can only do, no, I'm telling you, I'm telling you, you can only do it once, you can request one extension,
And is it for 1 year or 2 years?
Just one.
just the one,
Only one?
on a special permit, yes.
Mhm.
And after that, if it does expire, he does have to come back and do
You
a
have to
full
reapply.
formal,
Mhm.
yep, application.
Yeah, I would just point out, though, we just have to commence construction
Yeah, I
on it,
understand.
so it's not.
If he puts a spoon to the
I
ground, that's.
understand.
Any other questions for the board? Is there anyone here who wants to, I mean, not that it matters, but, well, yes, it does matter. Is anyone here that has a comment? Sorry. And this is why I don't have this often. I didn't mean that way. Is there anyone here who wants to speak on behalf of this? Okay. And it does matter, it always does. Yeah. I'm going to step out for a minute after that. All right, hearing nothing, I'll take, I'll entertain something from the board.
Is this a public hearing that we have to close?
It is a discussion. So,
I'd like to make a motion, we close the discussion.
okay, I don't think it needs to be that, but we
Okay.
can close it if that's your request. I
And-
don't think it needs to
And
be
that's, since I
that.
made the motion to grant the special permit, I'd like to make the motion to give Mr. Smolak a 1-year extension as needed and as requested.
Okay, is there any other discussions? Oh my God, hang up my hat. Okay, so, it's on the board, I knew.
I made the motion, someone's got to second it.
Doug did.
Oh,
I'll second the motion.
Doug did, I'm sorry. All right, all those in favor to grant the extension?
Aye.
You all set?
Thank you.
That was smooth.
Yeah. Can you have Al tell him that, thank you. Tom, didn't you miss this, Tom? All set. Actually, Rick sat in on both of those, his names are on it.
All right, so then, the next one we're going to do will be a special permit in the R4 district by Janet Etchler? Okay. 11 Tyler Road, so we can open that public hearing for you. Mr. Bias, how would you like to open this public hearing?
Sure, I'd love to. Notice is hereby given that the Board of Appeals will hold a public hearing at North Andover Town Hall, 120 Main Street, North Andover, Mass. On Tuesday, June 23rd, 2015, at 7:30 p.m. to all parties interested in the petition of Janet H. Etchler for property located 11 Tyler Road, map 33, parcel 7, North Andover, Mass. 01845. Petitioners requested a special permit to allow for a family suite from 4.122.22 of the zoning bylaws in the R4 zoning district. Application supporting materials available for review at the office of the zoning department located at 1600 Osgood Street, North Andover, Mass. Monday, Wednesday, Thursday from the hours of 8 to 4, Tuesday from the hours of 8 to 5:30, and Friday from 8 to 11:30. By order of the Board of Appeals, Albert P. Manzi III, Esquire, Chairman.
Excellent job, Mr. Bias. Welcome. So what you doing?
I want to add a small family addition to my Cape-style house on Tyler Road. In the interest of my parents, my mother is 91, she has dementia. My father is 93. They're both living independently now, but I'm always waiting for the other shoe to drop, so to speak.
Okay.
I also have an adult son who's having a little bit of trouble making ends meet in the rentals in North Andover.
Right, so it's a family suite that you're at. Looks like you have the area to do it. So you don't need a variance, right? And you submitted the elevations. Does anybody have any questions?
I just want to clear something up with our building inspector. We established long ago that because it does not increase the nonconformity of the lot, it doesn't affect. I just want to make it clear that it doesn't affect because that addition doesn't, it
There are
doesn't.
no violations of setback, height, or anything.
Even though it is it's non-conforming in the back. Because you should be, you're at 29 and should be at 30. Your lot, it's already existing, and your addition doesn't increase that or come onto it, so it doesn't affect the non-conformity of your lot.
Okay.
All the paperwork seems to indicate that there's only a single story both in the addition and in the main house, yet there are stairs in the plans that go up in the main house, and there's a spiral staircase in the addition that goes up. Where's that headed?
That is correct. These stairs go up to an attic on both counts.
Is the attic space finished at all?
How does it not increase the,
No more than a coat of paint.
how does it not increase?
So there's insulation and drywall?
There is. The previous owner had, there's evidence that somebody was living up there, maybe teenage kids.
What is going on with it? See?
Is it heated?
No.
I didn't think you could have a spiral staircase. Is that?
No, they're all single-family use, yes. That was existing also, Ellen.
Oh, okay. Outside, exterior they're not.
Pardon?
Exterior they're not allowed, or is it?
No, you're confusing egress with multifamily buildings. You can't have a spiral winder out for a second means of egress. Internally, in a single-family home, they are allowed if they choose to have them, and this was done a long time ago. And the applicant had nothing to do with that. That's the house she bought.
This looks like a fairly straightforward application.
It is.
Do we have a problem with the size of the addition, since, do the regs not state that we can only approve 25% increase in the GLA? And this looks like it's about a third, 33%?
If you look at the numbers, they're de minimis to what she's really trying to do, and I don't think that that's been really looked at as a fact of denying on any application that I've seen in my 10 years in this board. So you want to say that that's too large, then make them reduce it down? So be it.
Well, is your question, Paul, that there's a particular number standard that needs to be addressed or wasn't addressed, or?
I think I'm probably more particularly asking, do we have the authority to approve something north of 25% if that's what's stated in the bylaw?
Well, here's the thing, and I certainly might not be correct on this, but my understanding is, with respect to the special permit, we would have the authority to approve what's before us if it's properly filed and advertised. The building inspector is the enforcement agent. If he makes a finding that a particular bylaw requirement applies or doesn't apply, that's how it comes before us. So if you believe, the board could simply deny a petition if they don't believe it warrants approval, and we could cite our grounds for it. Or we could rely on the interpretation and enforcement of the building inspector.
Could I look at your code, Al?
My code?
The bylaw?
Yeah.
Sure.
Paul, I understand what you're saying. You think that another permit needs to be granted? Another special permit? Or a variance for building area?
Go beyond what the bylaw says.
Is that?
I don't want to put my name on a problem, that's all. I don't want to approve a problem.
I believe that's the most current.
Thank you.
All right, but not, apart from that particular issue, let's just talk about the merits. If I can bring us back around to the merits of the application. So, a few years ago, people in the R4 district were forced to convert their homes to two families because they didn't have the family suite option. I like to think that this board sort of helped get that approved at town meeting to correct what I was somewhat inconsistent in terms of all the other zoning districts, so people would have the option of being able to maintain the type of home they wanted and allow for family to move in. So, I think in the context of the special permit application that you filed, I'm glad to see that the bylaw is working and that you're here, and it's something that could work for you.
Thank you. I feel very strongly that I'm paying it forward for my family. I don't think there's any detriment to the neighborhood. I think it's a win-win situation.
I understand the question that Mr. Koch is
Yes,
raising.
I understand.
So, because it takes four votes to approve these types of petitions, which is effectively a supermajority. So he's raising a question in terms of the size. The question is, should you have also filed a request for some form of a variance or a waiver in size if it's bigger than what maybe the bylaw allowed? I don't know. I'm relying on what's before us. So, in fairness to Mr. Koch, we'll let him look that up. Yes, sir.
The addition is 16 by 28.
Okay.
That's 448 square feet. Where is Mr. Koch getting his numbers? Because the bylaw says, and I quote, for family seat can be 1,200 square feet. Where's the violation?
I'm not aware of any violation. I don't know.
Where's the violation?
It's because this is crystal clear, Jerry. The size of the family suite is not to exceed 1,200 square feet or not more than 25%, whichever is the lesser. So the lesser in
Of the
this
gross
case,
floor area of the entire building?
of the principal unit. So
It's not a unit, it's
this
one
is-
house, it's
this
one
is-
family.
this
You're
is-
reading
this
it
is
wrong,
topped
Paul.
out at
Paul, you're reading it
25%.
wrong. I beg to differ.
Yeah, I beg to differ too. This is crystal clear, Jerry.
No, it isn't.
This isn't a matter of interpretation. This is black and white. And, but where
In
I'm
addition
going,
to
Jerry.
that, there is an FAR calculation in this town on any building, and you're gonna, all of a sudden, you're gonna bring up the fact that FAR should be for this lady, for injustice to her family, so she can have a 448 square foot little addition?
We can continue the conversation, or we can be positional and confrontational, Jerry.
I'm giving you my
So-
side.
And I'm not looking for sides, I'm looking for information, Jerry.
Okay,
The
so I just
last,
gave
the
it-
last sentence
okay,
of the provision is, in no case shall an apartment be smaller than the minimum required by health and building codes. So what's the smallest unit allowed in the town?
I don't know.
That's disconcerting.
So you made a decision, Mr. Brown, based on the application that came in before you.
It's
So you're
disconcerting that our building inspector doesn't know the minimum size
Well, I'm
of
not-
of
you know,
a
I don't-
dwelling
you know,
unit.
Paul, I-
448 square feet.
I-
You think it's wrong, vote that way,
I don't
okay?
want, we're not going to cross-examine the building inspector about it. What I want to do is just keep us focused on the applications before us. Based on what you saw, based on what came across your desk, this is the decision that you made, and this is what was sent to us. So this is what's before us now. The statutory, are there any abutters here that are on the abutters list that wish to be heard on this? Okay, I don't see anybody here coming to the podium, I don't hear anyone, so I'm gonna say that there's no abutters here. If there's, I understand what you're saying, Mr. Koch.
Paul,
So you'll have to
what are
just
you
vote.
referencing?
Second?
I'm sorry, what is Paul referencing? Which one, what's that?
The family suite provision,
4.122?
2.37.1. The bylaw would max out a space at 331 and a half square feet. So we're north of that.
Okay, so what you're citing.
I'm looking at this.
What you're citing is the definition section of a family suite, right? That's the definition. 2.37.1, right?
Yes, sir.
Okay,
So
what's the
what-
definition?
This was sent to us under 4.122.22.
What's that? That's on page 35. I have the new one.
I have it, go ahead, keep going.
I have it on 35.
Does anybody else want to be heard while Madam Chair and I are looking at these up? Any other questions for the applicant?
No?
I have a question. Does the question being raised by Mr. Koch with respect to size, do you know how that would affect your ability to function in the petition that's before us?
Well, plans would have to be redrawn and downsized.
Do you know what the difference would be in size?
119
Chuck,
square feet.
talking over just 100 feet.
119 square feet. 4.122.
Yeah.
Can you find it, can you show it to me?
This is the new one that just came in. That's the definition of a family suite.
Right here.
Yep. Do you have it?
Well, I'm looking at one here. 4.122.22.
20.
Has anybody figured out the square footage of the actual house itself now?
It's stated on the plan, Alan. 1326 is the main house.
Okay, I don't have my glasses. Oh, existing floor space, I see 13. So that says it can't be no more than 25%.
I do think that the board has the authority to cure that through a special permit. I do remember, the board has very broad authority with respect to special permits. So if the board believes that that is somewhat de minimis, as
So what the-
our inspector of buildings may have found, that a special permit would ultimately control any difference that there may be with respect to size. I remember a few cases years back where the special permit issued by the planning board did ultimately control those sorts of things. So I think Mr. Koch is raising a valid point. I think Mr. Brown's interpretation is also valid, and I think it's just a question of, that's why we're here. That's why we're the Board of Appeals. You're appealing to us because you believe this is what you need, and we have to decide if what you're looking for is reasonable or not reasonable, and whether it comports with the neighborhood, and whether the board agrees with what you want to do. It's not by right, it's by special permit. And so either way, I mean, you have a definition of special permit, you have the other controlling language, and I do think that the special permit would ultimately control based on the finding of the inspector of buildings.
Can I say something?
Yeah.
I think a 1,300 square foot house in today's day and age is a rather small house as to the standards that really apply here to North Andover. And the apartment, excuse me, the apartment that she's proposing, I don't see any exterior exits or entrances. So I don't see how this could ever become, quote, a two-family.
They can't become.
Right.
A family suite
Yeah.
can never become.
I understand, but this makes it even harder, you know what I'm trying to say? That the only entrance is gained through,
Right.
okay, the house that's here.
If she came for just an addition, this argument wouldn't even be on the
Right,
table.
Right, if she comes from an addition, okay,
Right.
okay, minus the stove, this flies by. And she doesn't even have to come here, right?
Right.
Because she meets all the requirements. So why are we gonna punish this woman? Because she has a small home, and because of her smaller home, she's only allowed an addition of, quote, X amount of square feet. And like the chairman says, that's why we're here, to grant variances in special occasions. So I'm in total agreement of this.
But we're also here to follow the guidelines of the bylaw as well. So,
Yeah, I don't think anybody's looking to punish. I think Paul just raised the question.
Yeah, but you're punishing her because she has a small home.
no, it's.
Nobody's
no
punishing
one's
her.
punishing
He's
her.
just raising the fact that the
If she had a
bylaw.
2,000 square foot home, okay?
We don't want her to
Right.
have to build something that's not legal, that doesn't,
Yeah, but she's coming here for a variance to make it legal.
correct, and
She's here for a special permit.
she's here for a special
Right.
permit to make it a
Paul-
family
Paul
suite.
thinks she needs a
the whole
variance.
thing.
I understand.
Paul thinks she
Right.
needs a variance too, based on the definition under 2.37.
I understand where he's coming from.
But
I get it, I get it.
apparently Jerry did. So it's not, it doesn't say under 4.122 that I saw this language, but this language is in the definition. So the question is, I think for tonight's purposes, do we like what the applicant is proposing? Do we agree with it? Is there any objection from the neighborhood? Does it fit within the neighborhood? If the building inspector goes, the building inspector can still withhold the building permit. And that's the other, so you need 4 votes to get this approved if we close the public hearing. If, based on the information raised by Mr. Koch, let's say, for example, it was approved, and you went back in to get your building permit, and Mr. Brown then agreed with Mr. Koch's decision, it's possible he could send you back here for another variance. So that's something that could certainly happen. Or he could simply rely on his initial opinion that it doesn't need it, that the special permit would control. It's,
Throw another one at you. She takes the stove out. She's just getting an addition. We're not even here. I already actually got
That's
the
right, but
permit.
the stove is here now, so
we
we
have
can't.
to deal with what's before us. And what
It's a family suite, Jerry. I don't know why you get no, I mean,
I
the
just-
bylaw does say, the 25%.
I just don't like the insinuation from Mr. Koch coming at me in a public meeting. I won't stand for it, okay, Mr. Koch?
I think
You don't get that?
Jerry, I'm not clear what the insinuation is. I was asking questions.
No, you were being rude to me, and I won't stand for it, mister. Okay?
That's fair, Jerry. Everybody's
Okay.
entitled to their interpretation and
here's
their
the thing.
feelings. Unfortunately, this is a public meeting about an application that's before us.
I get it.
We have to be able to ask questions, because that's our job.
I get it.
If we can't ask questions, we're not doing our job, Jerry. I didn't take it, I don't think Mr. Koch meant it in an accusatory tone. I understand the nature of his question, Some of us that ask questions for a living, we just do it automatically, you know?
It's come up at other family suite
Every
discussions. the
time. This is not new
25%. I
ground.
know. it's.
We have this same conversation.
We've had it.
I mean, you make the stove argument every time, then take out the stove and don't come here. Don't give me a special permit application if we can take out the stove. That's simple.
Won't ever ask anyone to come.
That's too
I didn't ask them, they asked me. I'm trying to help them.
No, I
For a
think
little
me too,
small,
and then I was trying to
de minimis addition.
Let's
just
see,
bring-
Jerry,
And
one
it's
square
just-
foot
it's
is
just-
the same as 1,000 square feet,
No,
once
it
you
isn't.
exceed the authority of the bylaw.
It isn't, it isn't. That's what you're reading it wrong, because a special permit is not a variance. She's
I'm
not getting a
making any
variance, she's getting a
apologies for
special
reading
permit.
things literally.
There
I'm
is
not making any
flexibility in a
apologies for
special
reading
permit.
something critically. I'm not making any apologies for being an attorney and asking questions, Jerry.
Can we bring this back around, Jerry?
Yeah, I'm done.
And I was trying to find the loophole. I was trying to work with the building inspector, saying, what's the minimum size of a dwelling unit? If it's north of 450, 449, we're in, baby.
It is.
But you don't know. You said you don't know what's the smallest
Because
dwelling
I
unit
wasn't
allowed
ready-
in the
I
town of
wasn't
North
ready to
Andover.
Answer the question, okay?
Well, okay, but what's before us is the special permit. So what's ultimately going to happen is if the board approves what's before it, it still rests in the hand of the Commissioner of Buildings with respect to issuing building permits and the conformity as to the zoning. So if he's already made the ultimate finding, the board's choices are to approve what's before us or not approve what's before us. You know?
Sure.
I mean, ultimately, that's where I see this going. You know? And the questions are valid. We have to be able to ask the questions.
Well, the other choice is to have him come with a variance as well.
Yeah.
Instead of, keep it open and have him come for a variance.
The board could certainly do that, too.
Can I ask a quick one?
Dear.
Where's the stove on the plans? There's no stove on the plans.
Right behind the
In
toilet.
the
You see where the toilet is? Right behind the toilet.
refrigerator.
Yeah. You see where the bathroom is?
There's a refrigerator, a sink, and a dishwasher indicated on the drawings. There's no stove on the plans. There's no reason.
Regardless, it came as a family suite.
Understood, but
That's the legal notice.
that's the way it was legally presented to us, but technically, if she turned around next month and came back to us with the same drawings with a different application,
She wouldn't have to come to
With
us.
She don't even have to go to
we
you.
wouldn't.
She doesn't have to come here,
What do you mean?
right? She doesn't have to come here because she
It would
meets all
just
the
be an addition.
requirements.
Wait a minute.
All she has to do is buy a microwave
Yes.
instead of a
Say
stove.
that question again?
If she turned around and walked out the door right now and said, don't even have a hearing,
Yeah.
close the hearing, I'm done with you guys, she could file a different application with the same set of plans
Right.
and
I think she
reformat it with the building inspector.
She wouldn't have a legal family suite.
Yeah.
And I think that's what the issue is. So the question, she's here
It'd be an
because she
addition.
wants a legal family suite. So, you know, if her home comports to any other type of addition in the context of a single family, that was probably out of our jurisdiction. You know? If she wants to come back and file an application for a two-family at some point, she can probably do that too. But that's not what's before us. I mean, I think the way that you sort of, you know, address some of these issues that come up, you know, when they come up in the public hearing, the way I recommend we address them is you can put some controlling language into the decision, you know, in terms of not to exceed any specific square footages or things like that. If that makes you can grant an approval with some limiting language, or you can just approve it. You can just approve it, and you know, we can make sure on our review of the applications when they come in, that, you know, this is something that I didn't see when it came up initially. You know, we can make sure that before they get docketed, that it's something that gets checked as well. But I don't think I think the request for the special permit certainly comports with what she has, and as evidence of the fact that there's not an abutter here, and we do require certified notices to come back, leads me to believe that what she's proposing, it can make the leap is in harmony with the neighborhood.
I don't disagree with any of that. I don't need to be convinced on anything other than this is beyond my authority to approve. And the second it's 25.01%, you know, the increase is greater than 25%, it's beyond my authority.
But I understand that point, but you have to
The
understand.
mudroom is not habitable space, so that shouldn't be in the
But you have to
calculation that he
understand,
made. that
There's
is
a
not habitable
significant amount
room.
of discretionary authority in the office of the inspector of buildings and our building commissioner. He has the authority to make that decision within what he does. So we haven't required any certified calculations to come in with these applications. So I'm relying on what's presented, and to take an arbitrary number from the bylaw and somehow to just apply it, that's what he did. And I think what's before us looks
It's
reasonable.
not really arbitrary. I mean, town meeting came up with 25% for a reason.
But
I
how-
understand what we're.
I don't know how
I-
it's being calculated.
Oh, yeah.
Arbitrary in terms of how it's being, I don't know how he's calculating.
I don't know.
And we've never asked him to calculate.
Can I ask the building inspector
I don't
a
know,
question?
at your own risk.
Yeah, be careful.
Yes.
Okay.
But we're spending a lot of time. We got another hearing.
Yeah, I understand. Mr. Brown,
Yes.
if I read this correct,
Yep.
okay? If this board were to deny this application this evening, okay, for a quota family suite, the board denies it, let's say, she could still come in tomorrow
That's right.
and apply for a permit for an addition to a home
That's correct.
with the second bathroom.
Right.
That's all I want to know,
And she's going to get
okay?
it.
And instead of a stove, all she has to do is put a microwave in.
Right.
Okay.
She was trying to do the right thing.
She was trying to do the right thing.
Have a family
And we
suite
get-
for her family.
I get the message.
It's under the, remember, the verbiage of this is 1,200 square feet, okay? He's bringing up a de minimis number of, and the floor area of the entire suite, if you take off the mudroom, may even come into compliance of the 25% rule that he brought up.
To me, it's somewhat of an arbitrary number. I don't know where that number comes from.
But the
It's just a number.
point remains, we say no, she comes in tomorrow and
Right.
applies for a building permit, and she gets it, and you don't need anything.
Right, and you don't have to record it
Okay?
at the
You don't
registry.
need
of deeds.
anything. Okay, that's all I'm saying.
You're going to get
I
it.
think it's a number, my understanding of this bylaw and how it came to be is that's sort of a number that triggers the review. It was.
We don't draft the
it was-
bylaw.
No, but I have,
And-
gone to plenty of town meetings over the years.
Yep.
And, this is I've lived here for 41 years. This is my recollection of, how things have come to be.
But that's the absurdity is, and Jerry would agree, if it's just an addition, there's no questions asked. It could be more than 25%. I mean, it was done with the intent to keep people from building a family suite that was twice the size of the house.
Right, exactly.
But again, we weren't part of that.
Right, and between you and I didn't do the calculation on the percentile numbers that Mr. Koch did. I just went by, it was under 1,200 square feet, which is one small little room for her family to go to. I don't think over-interpreting this bylaw to mean exactly what Mr. Koch has stated is the correct way to go with this.
Jerry, again, I don't think he stated, I think he asked.
I know that.
Okay.
So here we are. So is there any additional information you'd like to offer on the record?
Are you sure? Wait, be careful.
Okay, off the record.
No, we're on the record.
Why are we making a meal out of this?
So, I think let me just comment. I think you have done a very nice job with respect to filing the architecturals. I think you've done everything that's been asked of you. And I'm even willing to bet that had you been asked to file something else, you probably would have. So, you prepared a plan based on what you believed you needed to prepare and submit. The parking situation. Parking, you have proposed parking here, so you have what,
Detached garage.
detached garage and some spaces, right? How much parking do you have? 5 spaces. So I think you've met all the criteria that needs to be met. I think it looks like it fits within the neighborhood. You understand how the family suite works in terms of what you need to certify and,
Only family.
right.
Believe me, I only have the best of intentions.
I know you do. We take the presumption that you do.
Thank you.
Does anybody have any other questions for us?
We've had people have cousins living in family suites, so.
And cousins' girlfriends.
And friends of cousins.
Arbitrary definitions. So, what we can do tonight, if you'd like us to move forward and vote on this petition tonight, we can close the public hearing, we can deliberate a little bit more, or we can just vote on your petition. If you feel like you'd like us to continue it for any reason, we can do that too. Frankly, I don't see any reason why this shouldn't be closed and voted on tonight. It's just one person's suggestion, you do need 4 votes for it to be approved.
I would like to vote.
All right?
I'll make a motion to close.
I'll second the motion.
Okay, there's a motion and a second. Everyone in favor of closing?
Aye.
Okay, is there any further discussion?
Alan, there does appear to be a mode of egress. There does appear to be a door off the mudroom.
Okay.
That was just an issue that you raised.
Oh, I see it.
Wanted to be
Yeah,
clear.
yeah,
Just
I
wanted to be
see it.
clear, that's all.
Yeah, I see it, yeah.
I'll make a motion.
Yeah, well, just let's make sure everybody's talked about everything that we talked about before we do, because if Paul and Alan have additional things they want to discuss, that's fine with me.
I'm just curious, personally, on an instance like this, wouldn't a homeowner find more value in a permitted project that is literally an addition as opposed to a family suite, since a family suite seems to have limitations imposed upon it? I mean, is that fair to say?
I don't know what a homeowner would want. All I know is what's before us and what's been asked of us and what's been offered on the record. And, we're just, I'm simply going to make my decision based on that.
Fair enough.
I'm not living there.
You don't have to rest
I'm not the realtor.
I'll make a motion to grant a special permit from 4.122.22 of the zoning bylaw for a family suite in the R4 zoning district. I will reference the plan drawn by Steve Stupinski from Merrimack Engineering, dated May 26, 2015, and architectural plans by Joel David Silverwatch Architect, dated some date somewhere in here. She did?
10/20.
Oh, this one's dated 5/19/2015? The architectural plan? 5/19/2015?
10/2014. Oh,
Date
yeah,
10/2014.
dated 10/2014 and revised.
Oh, and then, yeah, revised to 5/19/2015, referencing A1, A2, and A3.
That's my motion. That's my motion.
All right.
I'll second the motion.
Oh, good, we have a second. Motion and a second. All right. Okay, so why don't I start, Mr. Butch? Are you in favor of the motion?
Yes.
Yes.
No.
I am in favor of the motion. However, because you need a supermajority, the motion is denied. So procedurally, you can ask the board for reconsideration at this meeting, and the board can take up reconsideration to allow you to do further investigation to see what else you need to file. And I would hear that now, if you would like the board to have reconsideration. Otherwise, the motion would be denied, and you would have to file a new application. So, would you like us to reconsider that?
I'd like you to reconsider.
Okay. I would like to hear a motion to reconsider, because I don't think that the applicant really understood the gravity of what was going to happen to her petition with not getting 4 votes. We could reconsider this, allow the motion to be continued to the next meeting, give her an opportunity to work with the building inspector a little bit more to address whatever the issues were that caused it to be denied. Can I hear a motion for that?
I'd like her, I don't fully understand what you're saying, but I'd like her to continue the hearing, and maybe you should seek some legal advice between now and the next hearing that would enlighten you upon your legal challenges or your wants or not, but
The
you
board
would have to
would-
be a little more educated as to how you could challenge the board, let's say.
The board would have to reconsider the vote it just took in order to allow this petition to be continued, so she could do that.
Isn't it, all it is a variance? So it can, for building.
It's a whole new, a denial for this woman is a
Oh.
whole new application process for something that's supposed to be a simple process, a family suite.
Correct.
So,
But unfortunately, how the bylaw is written does not make it a simple
you
process.
know, I think it's a most unreasonable act that the board just took.
Correct.
So,
Oh, well.
Hopefully you understand that you could go in tomorrow and get a building permit.
I expect to.
Thank you.
So you don't want us to reconsider?
no, no.
Oh, okay.
Yeah, keep the options open.
We-
I'll make the motion to reconsider.
All right, we have a motion to reconsider. Is there a second?
I'll second that.
Oh, we have a motion and a second. So would the board reconsider the vote that just took to allow this petition to be reopened and continued to the August meeting?
Aye.
Yes.
Yes.
Okay, I would say yes. So, we'll let the record reflect, the board reconsidered its denial, the petition shall remain open. This will be continued to the August meeting, because regrettably, we don't meet in July. And then you can see what other options are available to you. Okay?
Do you understand?
I do.
Okay.
Okay.
You broke my heart.
Not me.
No, not you, not you.
Not me.
Okay.
Guilty by association, Al.
I guess I am.
You're on the end, Alan, so you...
Okay, and with that,
You want to take a 5 minute?
no, I want to, do we need to find that? I want to get right into it.
Yeah.
All right, we're going to take a short recess. I will recess. address with you, Attorney Rosen. All right, so the first relates to the voting members here tonight for your petition, because to the extent your petition is not resolved at this hearing, and to the extent that it's continued to our next regular hearing, Mr. Byers wouldn't be on the board to hear that. So he would participate this evening if he so chooses, but we would still have 5 members, okay, that could hear it.
1, 2, 3, 4, 5
Yeah, so
would be
the-
the voting members if it got continued to August.
So tonight's regular members, Mr. Koch, Mr. Byers, myself, Ms. McIntyre, and
Okay.
Al, Mr. Kuchar. Tonight, Doug and Denny are associates. In August, Rick won't be here, and Doug would be our new regular member.
And as long as he's here sitting and listening tonight, he is a voting member at the August
Correct.
hearing if it continues to August.
So long as he accepts his appointment as a regular member
Okay.
and signs the book. I mean, that's still on him whether he chooses.
And that is your indication at this point in time? Okay.
So long as he chooses to accept that. So I want to make sure you understand.
Yes.
Because I think it's a rather complex issues that are before us tonight. I think it's possible it may not get resolved in one meeting, and so I just want to make sure you understand that going forward.
Yes, thank you.
Okay. The other thing that I want to get on the record and make clear of is I did file a 268A disclosure notice to dispel an appearance of a conflict of interest, because years ago, from 1996 to 2000, I worked for Aussie Property Management, Inc., of which Ms. Marie Goldstein was the president of that company.
Correct.
And so it was a long time ago. I don't have any financial ties or anything with Ms. Goldstein. I assume it's the same, seems to be the same Mrs. Goldstein that
Yes.
would be the principal of the Lucent Properties and Osgood Solar and everything that seems to be happening down on these Lucent sites.
Yes, same principles.
And, it's also my understanding that my family may have an access easement over property of hers off of Foster Street, so a right to pass and repass, of which I do not, but a family member may. It's no conflict for me. I don't believe it affects my ability to be impartial or make fair, objective decisions or in any way administer this hearing whatsoever. That being said, if you would like me to recuse myself from this hearing, I am happy to do so, and I will hand the gavel to Ms. McIntyre, and she can take over.
Thank you. So for the record, we appreciate the disclosure, and we do not believe there to be a conflict. It has been more than 15 years. The parties parted on an amicable basis and, don't have any financial interest and have not had any financial interest going forward, so we do not perceive there to be any conflict.
If that's your decision, I believe I can maintain a fair and impartial balance with this hearing, so.
I do have one procedural question, if you're done procedurals before we get started. So we asked for 5 findings, and one question that I do have as we go through the process tonight is, will we take one finding at a time, discuss it, and possibly close it, and possibly deliberate on it? One concern I have is that in going through the legal morass of 5 of them, it could get confusing as we get to the 3rd, 4th, and 5th ones, and there will be, as you say, a lot of information. Quite possibly, maybe we try and get through the first couple tonight, see where we stand, but I do think it would get significantly more confusing if we tried to do all 5 at once, then close them, and then try and deliberate on 5.
My suggestion would be, in my past practice, in terms of how I tend to chair these meetings, is I would have the public hearing open with the legal notice that was advertised. So everything is on the table. You would then begin to address each particular point as you wanted to address it in the course of your presentation. I think, as it relates to voting, what we would likely do when the public hearing is closed, I would vote them one at a time in a particular order. So if there is a particular issue that is the main finding as opposed to, we would have to make decisions on everything that was advertised.
You know what, Al, I'm not comfortable talking about this until this is open. I mean, because you're talking about findings.
Hold
Can
on.
we open the
No,
meeting prior to talking
no,
about
I'm gonna-
procedural?
Yeah.
Before you talk even any more procedural, I prefer to open the meeting.
Okay, well,
Otherwise, I'm gonna leave and not listen to anything else until it opens up.
Leave Ms. McIntyre if you want.
I will, until it's opened up and open to the public.
Kind of let me finish what I started. So that would be, we can say it all again on the public record, and I'm happy to do that. So that's how I would approach this hearing, okay, is we would open it like we would any other meeting. Everything would be addressed in the context of the public hearing like any other meeting. And, when we vote them individually. That's how we address it. It's not going to be any different than any other hearing that we have.
Okay, thank you.
All right? So with that, I would ask whoever wants to, Mr. Byers, if you would like to.
Sure.
Open the public hearing. And I will say that all again on the record in the context of the public hearing.
Notice is hereby given in accordance with Mass General Law 40A that the zoning board of appeals will hold a public hearing at the Town Hall, 120 Main Street, North Andover, Mass. on Tuesday, June 23rd, 2015 at 7:30 to all parties interested in the application of Osgood Solar LLC located at Osgood Landing, 1600 Osgood Street, North Andover, Mass. 1845, map 34, parcel 17. The property whereby the applicant is requesting a finding as a party aggrieved from the building commissioner's determinations dated March 24th, 2015 to the zoning plan, to the North Andover Planning Board for the property that is subject to the Osgood zoning bylaw and located within Osgood Smart Growth Overlay Zoning District with respect to the following. Section 17.3.2, underlying zoning as to the property, that the term site, a term that is undefined by the zoning bylaw, is not defined to mean lot. A term is defined by the zoning bylaw, and further, that the Osgood section of zoning bylaw contemplates multiple projects on a lot. 2, section 17.6.3.2, as a right use is under plan approval by the plan approval authority within the business opportunity zone located within Osgood Smart Growth Overlay Zoning District, that the building commissioner erred in applying section 17.6.1.2, and further that manufacturing includes renewable or alternative energy manufacturing, such as solar generating facilities, as an as-of-right use. 3, section 17.6.3.3, uses allowed by special permit within the business opportunity zone located within the Osgood Smart Growth Overlay Zoning District by plan approval. Special permit issued by the plan authority, approval authority as special permit granting authority, that the building inspector erred in his determination that the solar photovoltaic system consisted of an application for special permit when in fact it was an application for Osgood plan approval by pursuant to section 17.6.3.2 as an as-of-right use. 4, section 17.6.4 prohibited uses with respect to the business opportunity zone located within Osgood Smart Growth Overlay Zoning District, that the building inspector erred in his determination that solar energy generating facility is not expressly allowed and therefore prohibited use. 5, section 4.33 11B in the Industrial 2 zoning district in section 17.6.3.2, that manufacturing as it relates to solar energy generating facilities is not limited in any way to preclude the transmission of all of or any portion of the energy being generated for use off of the property. The applicant refutes the building commission's determination dated March 24, 2015 to the North Andover Planning Board. The applicant's proposal is for the construction of a 6-megawatt rooftop and parking canopy mounted solar photovoltaic system. The proposed system is to consist of 19,500 solar modules, approximately 5,500 rooftop mounted solar modules, and approximately 14,000 modules mounted on structures approximately 39 feet wide, comprised of approximately 21 rows ranging from 150 to 630 feet long. Application supporting materials available for review at the Office of the Zoning Department located at 1600 Osgood Street, Suite 2035, North Andover, Mass. During regular business hours. By order of the Board of Appeals, L.P. Manzi, 3rd Esquire, Chairman.
Okay, thank you, Mr. Tice. Okay, before we get started, is to Mr. Leary presenting. So procedurally, with the public hearing open, you can present all of the issues as it relates to what's been advertised and the relief that you're requesting in your aggrieved position with respect to the building inspector. We will vote on each particular application when the public hearing is ultimately closed, whether it be tonight or another hearing night. I will vote them in one at a time, okay? So we'll call the votes like we had talked about earlier. With respect to what's on the record, I have taken the liberty of communicating with the town clerk. Because we're dealing with an overlay district and an interpretation of the overlay district, and there's an underlying zoning that has interplay between Chapter 40A and Chapter 40R, which was the overlay, and how certain applications go before the planning board proposed as an as-of-right use, and certain applications go before the planning board as a special permit use. And because there are 3 specific overlay districts as it relates to the Osgood property, from the town meeting approval for the Osgood overlay district, I have asked the town clerk, Ms. Bradshaw, to submit to us on the record copies of the overlay district map that was approved at town meeting, a certified copy of the bylaw itself, so we're all working from the same bylaw. I think it's section 17. And there may, maybe, I think it was a copy of the warrant article as well, and there may be other information that we need. One particular notation that I saw in this bylaw as it relates to electrical distribution, to the extent that becomes an issue before this board, is subject to the rules and regulations pursuant by the Department of Public Works. I don't know if that has in fact been submitted to this board. It's referenced in the bylaw. I don't even know if it's relevant yet, but there may be additional information this board needs to get. I understand you got a petition before the planning board. I don't know where that stands yet. It's quite possible the planning board may have to adjudicate that matter before this board can ultimately adjudicate this matter. So, we don't want to prejudice anything. I want you to present what you need to present, and we're going to work through it as best we can. Okay, so with that, welcome, and here you go.
Thank you, Mr. Chairman and members of the Zoning Board. My name is Dan Leary, and I'm part of the team working on Osgood Solar. Mr. Chairman and members of the board, every generation has the opportunity to make a positive impact on our town. And I say this simply because tonight we're going to be discussing one such project that could partially define our generation. I thought before we spent the evening discussing the legal definitions of site and manufacturing, though, that I'd just take a moment to describe why we're here. Our team seeks to develop a solar array on underutilized space at Osgood Landing. This includes parking lots and the rooftops. In fact, enough sunlight lands on the parking lots of the old Western Electric plant to power every municipal electric meter in town.
Can I stop you for a minute? I don't mean to stop you, but I want to make sure that the board's clear on what we're being asked, because it was a rather lengthy legal notice that was read. So we're being asked to make a decision with respect to use, correct? As it relates to whether the applicant, Osgood Solar, Lucent, has an as-right use to put these solar panels in, as opposed to the finding of the building inspector's letter that's currently before the planning board. And so, you know what, could you give just a little history to this board so they understand exactly how you came before us tonight?
We were going to just show you what it was, but why don't I just jump in?
I think it's important that you jump in, you get to the meat of where we are, because there's a lot of, because I don't mean to cut you off, Mr. Leary, but I don't want us to get lost in terms of what we're doing. All right? And then,
I assure you, Mr. Leary, we're going to come back to that.
And I'm gonna
because
give-
I'm extraordinarily interested in what you have to say.
I am too, and I'm going to give you an
I think it's
opportunity
nice
to
and
talk.
would be a nice light, fluffy introduction before we get into what is the Byzantine morass of regulation.
Yeah, I just want to cover it because I'm very interested in your presentation too, absolutely. But I want the board to have the framework, the context, if you will, of what you're talking about, okay?
And can I just add?
Please, sure.
At any point in time as we're discussing this, if you would like Mr. Leary to come and show you how it applies on the board, please just let us know. Again, there's a lot of information here, and I thought maybe a brief overview at the beginning, but let me jump in. I'm sorry, Michael Rosen, I'm attorney for Reeve Goldstein and Osgood Solar. What I handed you is 4 documents. The first 2 pages is a synopsis of what we think the 5 findings we've requested tonight. The second is a letter from the building inspector, which is the basis for which we're before you, because it is the determination set out in this letter that we're asking you to reach findings on. The third is a series of, it's about 7 or 8 documents. It includes a list of the tenants at the property, their start date, their use and their square footage, along with the I-2 allowed uses, the business opportunity zone as of right uses, and the business opportunity zone special permit uses.
So
And then,
not to confuse my board members, it's a summary of, those uses are the same uses as is in the certified copy of the bylaw that Ms. Bradshaw gave us.
correct, to the best of my knowledge, I clipped them directly out of the town's website today on the most recent version, and I kind of compiled them to make it concise and put,
So
you know,
I'm going to ask you at some point to review the record as to the certified copy that came in.
Certainly.
Because I want to work off what came from the town clerk
that's fine.
in terms of the allowed uses, the special price. You know, I mean, I understand the summary and I appreciate it, but just so everybody's working off the same document.
Certainly.
All right.
So this project, the application for this project started back in March, and the project was submitted for plan approval in front of the planning board. At that time, the planning board, I believe, reached out to the building inspector and asked for some guidance on use, at which point the building inspector's letter, which is the second document dated March 24th, went back to the planning board. Since that time, we've had 2 hearings in front of the planning board. Planning board has continued the hearings. They sought advice of town council. They understood that we filed a notice. We filed an application for finding before the Zoning Board of Appeals, and it was their belief, I presume after some consultation with town council, that we ought to go forward with this hearing this evening to get those determinations, because it would directly interrelate to how they viewed the planning board application, i.e. was it under I-2, was it at an as-of-right, or was it an Osgood special permit? So to your question.
That's interesting to me, because when I read the section 17 of that bylaw, it seems to me that that authority rests with the planning board. The planning board, you either submit an application for a special permit or you submit an application for an as-of-right use under section 17, and the planning board ultimately makes that decision. And here they have not.
They went to the zoning enforcement officer for a determination on use. That determination was issued. We think that determination was wrong. I think, you know, quite frankly, it's probably not much different than the last hearing where somebody goes and seeks a permit and the zoning enforcement officer for the town is the building inspector. They give their initial determination, and then you have to seek guidance from the boards based on the bylaws. Under Massachusetts law and under your bylaws, the only board that is authorized to reach a finding on a zoning enforcement officer's determination is this board. There's nothing in the Osgood bylaw that vests in the planning board the ability to reach a finding on a zoning enforcement officer's decision, even if it's under 40R. So, you know, for that, in the summary of laws that I put in, I did put in the provisions of 40A Section 7 and Section 8. 40A Section 7 talks about how the inspector of buildings makes the determination and is charged with the enforcement of the zoning ordinance or bylaw. And then Section 8 determines that an appeal has to be taken to the permit granting authority, which in North Andover is the ZBA, which is why we're in front of the ZBA.
Right.
So specifically, it is the letter. And that letter, even though the letter has 4 findings, it actually has a 5th determination.
But how do you believe this is different from the section 32 of Article 17, the Plan Approval Authority, the PPA, which is effectively the planning board? They're the authority that has the ability to make those.
So a plan approval is not a special permit. Plan approval is a review, and a regulatory review to determine conditions to impose on a plan, not an authority to decide whether or not a use is or is not allowed. That's not what plan approval authority is. It doesn't exist under Mass General Law. It doesn't exist under 40A. Plan approval is a creature of common law, not of statute. Okay? So because of that, under 40A, the authority first comes to this board to make a determination on the building inspector's decision as to use, and then we wholeheartedly believe we're going to be back in front of planning board. The only question is, when we go back in front of planning board, what are the criteria that they have to go by in order to make a determination? Are they looking at site plan review under I-2? Are they looking at plan approval under 17.6.3.2? Or are they looking at plan approval special permit under 17.6.3.3? And it's your guidance that we all need to determine what section they should be acting under.
Because the way that 17 is written in the position that the building inspector has taken is if the use is not expressly allowed, it's effectively prohibited.
Well, again, we're going to walk you through that, and I'll explain why I think the building inspector was incorrect in his determination and why I think this board can make a determination. My honest belief is that I think you're going to make a determination that there is more than one way that it's allowed, and that choice should be ours. But it's going to take me a little bit to walk you through it, but hopefully not too long.
I have a quick question.
Sure.
Our town decided that this is 40, that in town meeting, there was actually, I think, only 2 of us that were opposed to it in town meeting. So do you go under 40R or 40A, since you're zoned 40R?
Here's the first question. This
Yeah.
is the very first issue and the very first
Because you talked
finding.
about it, which is confusing to some members.
So, your zoning enforcement officer literally read your statute 17.3.2 to say, within the boundaries of the Osgood, a developer may elect to either develop a site in accordance with the requirements of Section 17 or to develop a site in accordance with the requirements of the regulations for use, dimension, and all other provisions of the zoning bylaw governing the underlying zoning district, meaning I-2. So the issue was, does the applicant get to make the determination? So the question literally becomes, may develop a site in accordance with. And really, the question becomes, what is a site?
That's not my question. So you're referring to 40A as opposed to 40R.
No, I'm referring to both right now.
So does one govern over the other?
No. No, it's an overlay district. Underlying zoning still applies, 40R applies. And then you have to look to the regulations both in 40R and 40A to determine, as to any particular application, which one a board should take into consideration.
For me, I'm seeing which one is more convenient, 40A, 40R, Section 17, Section 4. So is it, for me, I like to go to one, is it so?
Again,
right.
if you give me...
Before you do any of the findings or any of that, the whole application itself is the reference to 40A or 40R.
Both.
Well, let me,
If I can get through the very first issue, you will see exactly what the underlying, and it goes right to, it is exactly your question.
Okay.
Okay, so the 40R model bylaws, which is what your bylaw was drafted off of, use the word project. Your bylaw uses the word site. Your bylaw in general defines many things. They define lot, they define plot, and they define parcel, but they don't define the word site. So the issue becomes, when you look at this property, and if you take a look at the maps in front of you, at this point we're talking about the blue parcel, which is approximately 130 acres. The question is,
but they did define, the bylaw did say, just for discussion purposes, it did create an overlay district in different shades of color.
the overlay district that we're talking about is the business opportunity zone. It is approximately 130 acres, and it is the parcel in blue. So the question becomes, does the lot, capital L lot, as defined in your bylaw, equal the exact same thing as the term site, lowercase s, as used throughout the 40R bylaw? Okay, if the word site means the lot in its entirety, which is how the building inspector interpreted it, then his argument is that once you pick either 40A or 40R, you're done, and you have to be either in 40A or 40R. My belief is that is incorrect. My belief is that a site is a project. It is a particular use. Maybe it's a building, maybe it's outdoors. It is a particular use, a particular project, a particular application that is placed in front of a board, or maybe doesn't even have to go in front of a board because it's allowed as of right. And that each application or each site, each project should be viewed one at a time. And so to answer your specific question, I can't tell you whether we're under 40A or 40R until we figure out whether site means lot, and then as to this property, are we, as a matter of law, restricted now to either one or the other? Okay. And the reason I can't decide that is this. If you go into the colored tables, okay? So I give you all of the tenants at the property, and I summarize those tenants for you, and I go through the effort of highlighting them for you, okay? Yellow is office. Green is manufacturing. Pink is recreational. Orange is retail. Purple is educational. And blue is warehousing. All of those uses are allowed in I-2. Recreational, educational are allowed in I-2. However, when the applicant, or when the tenant, not even the applicant, when the tenant for the community theater went to go and apply, they went into the building department and they said, oh, we're building a theater. At which point the building department said, well, then you need to apply under the Osgood bylaw. I'm sorry, the Osgood bylaw. Because the Osgood bylaw has a specific provision for theaters. So even though the underlying industrial allows recreational uses and it allows schools, Osgood has a more particular provision that says theater. So they went and they applied for an Osgood permit, and that was it. And they got their Osgood permit and they moved forward, and they have their theater, which, by the way, isn't a theater. It's a room with folding chairs and where they teach classes, including my son. You pay, you go to camp, you learn how to be in a play, and the last day of your 3-week session, you put on a play for the parents. That's their theater. When we went to apply for the solar, we were told, no, you've used Osgood, and you have a theater under Osgood, and therefore you can never use I-2 again. You made your election. But here's the problem with that analysis. In 2005, the property had 163,277 square feet of warehousing. Warehousing is not allowed in Osgood. It's only allowed in I-2. So in 2007, when you adopted Osgood, effectively, we could have never used Osgood because we already made the election because we have non-Osgood uses.
Are you saying that that particular use was limited to the business opportunity zone?
I'm sorry, which particular use?
That
Warehousing.
The warehousing?
Was that within this business opportunity zone?
Right now,
Or was it-
every building on the facility is in the business opportunity zone. Every use is in the business opportunity zone, except for some outdoor things like the town soccer league, the carnival on occasion.
So there's no structures in the mixed-use zone, and there are no structures in the residential zone?
I don't believe so at this time, no.
And I'm drawing on this again from the approved
Correct.
overlay district map.
Correct. Okay, so then Osgood passed in 2007. From 2007 till 2014, the owners of the property continued to get permits, all under I-2. They got permits to the point of having tenanted about 650,000 square feet of space, all under I-2. So they continued to make the election, I-2, I-2, I-2. In 2014, I'm sorry?
Who's they?
The owners.
The owners.
In 2014, a tenant went in and applied under Osgood and got permission to put in the theater, 10,000 square feet. After the theater went in, the owners continued to put new tenants into the property, get permits, get building permits, build space to the tune of an additional 20,000 square feet. For a year after the theater went in, they continued to apply under I-2, and go in and get additional permits and approvals. Only when they came to town with the solar project this past March were they told, oh, no, 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 you elected Osgood, you can't do I-2 anymore. The problem is that in a 710,000 square feet of leased space, 700,875, 98.6% of it is leased under I-2, not under Osgood. I'm sorry, not under Osgood. We've only come once for an Osgood special permit in 8 years. It is our belief that this isn't wrong. It's our belief that this is correct, because the word site doesn't mean lot, parcel, or property as those terms are defined in the bylaw. Site means, tell me what the project is. The whole point of this was to take a piece of property that's 167 acres and create multiple uses, to attract multiple tenants, and to create the greatest flexibility to take a property that at one point was the highest taxpayer and had the most employees in the town and get it back to that place.
Is Osgood paying taxes now?
Yeah.
It's,
There's a TIF in place,
Yeah.
so there's some incremental that's requiring them to make investment, and there were some other, well, I think there's a TIF, but I mean, they're a taxpayer. Their taxes did not go down from the time they took the property on, and quite honestly, the value of the property really hasn't gone up since they took it over. They put in about $2 million, $3 million in investments, maybe $4 million to fit out things for tenants, but unfortunately, they haven't built any new buildings yet. This would be really the first major construction development project at the site.
not towards a 40R, how they wanted it originally.
We had people under contract and they walked away. Well, unfortunately, the real estate market fell apart in 2008. We had, an agreement in place to build all 530 units, and in 2009, the people walked away. Property's been on and off the market on multiple occasions over the past 6 years. If we could find a buyer for it, and we could find somebody to go and do the development, we absolutely would. One of the reasons we feel like this project is good is because we actually think it will create some buzz about the site. Putting in car charging, putting in solar, putting in carports. It's kind of like a Google type of thing. Everyone wants to be where it's trendy. And maybe this will help us attract a company that's really committed to being somewhere green, somewhere environmentally friendly, somewhere that generates all its own electricity, and that has some of, I guess, what you would consider some of the more modern technological features.
Just for the record, just to let you know, Osgood was very instrumental in crafting Section 17. They're involved in that.
Absolutely positively they were involved. The town was,
I just
my
need
clients
I
were.
just need it out there.
Yeah, no, I believe Dr. Goldstein, Jeffrey, was involved in meetings with Kurt Bellavance and other members of the town. Yeah. So, again, my point is, we've got, you can see the list. You got 2 pages of tenants. Substantially all of them came after 2007. 98% of the property is under I-2, and we've been permitting I-2 between Osgood and before the theater, and since the theater going forward, we've been permitting I-2. Only when we came to do solar did somebody say, hey, wait a second, site means the entire parcel of land, and you can now never do anything unless it's allowed in Osgood. I-2's done.
So,
So that's the first.
Is that okay?
all right, so, so that, if I may, I believe that position came out of section 17.3.2 of the underlying zoning, where it says a developer may elect to either develop a site in accordance with the requirements of this section 17, or to develop a site in accordance with the requirements of the regulations for use, to mention in all other provisions of the zoning bylaw governing the underlying zoning districts. Is that a fair assessment?
Yes, and so it is our request for finding that, in this instance, site means essentially project, not entire parcel, and that on a project-by-project basis, we can make the election as to whether we're going under 40R or 40A.
So let me ask you this. Do you agree that a site would be one of the 3 sub-districts as identified on the plan?
No, I don't.
Okay.
I
And-
mean, again, the business overlay district is approximately 130 acres. I don't think that's a site. I think
Well,
that's,
but there are particular sites within a parcel that have all various types of uses. So you couldn't take the use in the residential district and apply it to the business opportunity zone.
correct, and we're not,
If they're not stated within there. right?
correct.
So if you don't believe that that's a site, then what do you believe is a site?
A project.
You believe-
Depending on what you're doing, I think you can identify the site, and to the extent that the zoning board, the building enforcement officer, or the planning board believe that you've reasonably determined that this is the project we're doing, this is the site. I'll give you a good example.
Any
okay?
particular, any particular application, you come in, whether it's 2,000 square foot here or 2 acres over there, an application is a site, as long as it's
No, I
identified.
no, that's not what I'm saying.
Okay.
Okay, I think if you were building a particular building, okay, and that building, you came in and you proposed to build a retail building that might have 6 tenants in it, I would consider that a site. And let's say we came to build a property here, this retail building, we would define that as a site. I wouldn't then come to you and say, well, I think this is industrial and I can manufacture in here. Oh, and by the way, I think I can put a supermarket in here. Oh, and I believe I can do. To me, that would be a site. I don't believe it's every single inch by inch is its own site. I think it's going to take some common sense.
Are the
I think
are
it's
the
going to
parcels in
do.
common ownership? Is it one parcel of land, or is it,
There's 2 owners of the entire property.
so are there 2 parcels? Just like
As a matter of law, there are 2. The red is Osgood Residences, LLC.
Yep.
And the green and the blue are Osgood, just Osgood.
Okay. And
Okay.
do
So, and
you don't believe those are sites?
No, I don't. I believe those are lots or parcels, as your bylaw defines them.
Okay.
Mike, can I ask a quick question? Just, is an example of what you're trying to say is Jessica's Bakery. I'm familiar with Jessica's.
Yes.
They came in, they went in, they're a manufacturer under I-2, correct?
They're a manufacturer. They technically would qualify under 40R as well, but we didn't have to go for site plan special permit for them. We didn't have to go for site plan approval for them. They came in under I-2.
That's what I'm trying to get at.
Yeah,
Okay.
they just came in under I-2. They came and applied for a building permit. They got their building permit and they opened.
Right, okay.
They didn't come in under 40R.
That's what yeah.
But
You see what I'm-
even more
yeah.
so than that, we have 2 warehouse uses that are each over 150,000 square feet. And warehouse is not an allowed use under Osgood, under the business opportunity zone.
Okay. So when you talk about a developer may elect under 17.3.2, was it expressly defined anywhere in this bylaw how a developer may elect? Does it have to be in writing? Do they have to
No,
tell the
it's-
town? It's just been the practice on application by
Just been the-
application?
That's just been the practice for 8 years.
Okay.
And again, until that applicant went in and was told, oh, no, you have
Are they
to.
told how to apply, or does the developer, or does your client or a particular applicant come in and say, we're applying under I-2 or we're applying under 40R?
Honestly, they've just come in and pulled building permits. Twice they've been told, no, you can't pull a building permit. You have to apply with an Osgood application. The first time was for ACT, and the second time was for solar.
Okay.
What was the first one?
The theater,
Oh, the
ACT,
theater, okay.
I'm sorry, Andover Community Theater.
And that's the extent of the election process for the
That's
past
it.
8 years?
8 years, that's it.
Nothing else?
Nothing else.
No formal communications after all the work and all the publicity? of the-
Not that I'm aware of. I would ask.
So, well, I'm going to let the building inspector, they're going to get
Okay.
their fair chance to.
Yeah, we go, I guess.
Say
we would
whatever
go
they
through
want, believe me.
Technical review committee, we would go and meet with the building department to pull building permits, go over issues that relate.
So you follow somewhat of a standard practice in terms of?
Yeah.
Okay, so there's nothing special that happens?
Nope. And I can tell you, the only 2 that have ever gone before the planning board are the theater and the solar.
All right.
Laser Craze came to us, but that was something else.
They did, I don't
I think
know.
because they had machines.
That was because it was
They had the
a sign.
coin operated machines.
Oh, that's right. So it's called sleep.
The warehousing uses that have been installed subsequent to OSGOD implementation, was there a warehouse use in that space prior to the OSGOD implementation?
It was vacant. I mean, this is a 1.7 million square foot facility. When Lucent finally vacated the property, at one point they were down to about 353,000 feet. So there was about 1,350,000 square feet that we had to leave vacant. Lucent wouldn't let other people in the building while they were still in there. Then when Lucent got out, we were in anticipation of that, getting leases ready to go. So essentially, the entire property was vacant when Lucent moved out in, I'm going to say 2004. I think the first lease was 2005.
Was there any element of Lucent's occupancy that involved warehousing?
Yeah, the warehouses physically were built and were there. There's warehouse space there, there's office space there, there's a cafeteria there, there's an auditorium and a theater in there.
Okay, so the use existed prior to OSGOD implementation, and the use either was reinstated or continued subsequent to OSGOD implementation. So there's basically always been warehousing at the site.
In different areas of the site, yep. I'll give you another example. If you're looking for something that was never there, retail, Cub Scout store, Boy Scout store, never there, not allowed under OSGOD, but allowed under I-2. Went in, got a permit, opened up, and there's a retail store in the building. Not a pre-existing use, it was never there, they didn't reoccupy a space that Lucent used for a retail store. They just went in, just course of conduct. The educational, the tractor-trailer school, Northern Essex Community College was in there. Laser Craze was in there. Uses that were never, what's the word I'm looking for? Native to that property. Just went in, filed applications, and went in.
But we're allowed under
Yeah.
40
So if I look at the business opportunity zone, 17.6.3, it talks about the intent of the business opportunity zone is to encourage efficient land use by facilitating compact, high-density retail, commercial, industrial development, and other commercial projects, and to facilitate development, land use density, and design that supports public transit if applicable. Then there's a section here that talks about as-of-right uses, of which it lists 1 through 18. And then it talks about uses allowed by special permit, which lists 1 through 13. It says prohibited uses, all uses not expressly allowed or prohibited. But then they talk about the criteria for special permit and other applicable approval by the plan approval authority. And I guess what I'm lost on here a little bit, probably because we're not involved with it enough, it just lays out the criteria with which the planning board can make this decision.
For a special permit. And that's the section on special permits. When we're not applying for a special permit.
It says any development component, this says may grant a special permit or other approval within the framework of section 17, only after holding a public hearing, which must be held within 65 days. The applicant is responsible for transmitting a copy. It says it shall not approve any such application for a special permit or other approval, which I'm assuming is the approval process, not the special permit.
No, the
Because
plan,
they're gonna approve them both.
that's not correct. There are sections that talk about plan approval, special permit, or other approval. In addition, plan approval is a 120-day process, not a 65-day process. 65-day process
Well,
is...
plan approval would be for an as-of-right use, right?
Yes,
So those first as-of-right uses, that's a plan approval process.
that's plan approval. It's
That's not-
120 days. It's not an other approval, and it's not a special permit. It's not the 65-day process.
Well, what
It's
is-
the 120-day plan approval process, which is a different section of the bylaw.
Does it say what an other approval is? Is that defined?
It does not, no.
So, in my view, they could.
But there's a section that says if you're looking for a plan approval, special permit, or other approval, which certainly leads you to believe that or other approval is not a plan approval or a special permit.
Yeah.
Plus, plan approval is specifically defined under 40R and under your bylaw as an approval that goes before the planning board under certain special criteria set out in section 17 on a 120-day process.
So walk me through a plan approval. What is a plan approval for an as-of-right use?
Site plan review, essentially.
That's effectively a site plan review.
Yes.
You walk in, you say it's as of right,
Yep.
And that's
Here's
it.
our plan, tell us what conditions you want to impose, tell us what your issues and concerns are, how can we address them to make everybody happy?
So it's a site plan, not a lot plan approval.
It's a site, bingo, yeah.
It's a site plan approved.
It's
And it
essentially-
differ- And it differs from a special permit approval process, just in terms of the criteria?
Well, special permits are, as a matter of law, they are governed under 40A. Special permits have a constitutional due process element to them. They have a higher standard, and the rules and regulations for special permits are laid out under 40A. Plan approvals, site plan approvals, are a matter of common law. They don't have the underlying constitutional due process, and as a result of that, they can only be denied in the most egregious of circumstances. The whole point of a site plan approval is to condition and regulate, but not to deny.
All right, so my next question is, if manufacturing is allowed as an as-of-right use,
Correct?
and it's listed under 17632, did you apply for a planned approval authority with the planning board, or did you
We
apply
asked-
for a special permit?
We asked for plan approval. We were told we were being subjected to the special permit. And if you read the letter and one of the finding requests we're asking for, the fifth request I asked for, I point out that the letter has 4 findings, but I asked for 5 determinations. And the reason I asked for the 5th determination is because the building inspector couched our application as a request for a special permit, when it isn't a request for a special permit. He considered it a request for a special permit. He also, under Section 2 of his determination, or our finding request, deemed it to be under 17.6.1.2. But we're not asking under 17.6.1.2. We're asking under 17.6.3.2. So 2 of the findings that we're specifically asking for tonight are, it's plan approval, not a special permit, and it's 17.6.3.2, not 17.6.1.2. Our belief at the end of the day is we're allowed under I-2, we're allowed under 17.6.3.2. Under I-2, we need site plan approval. Under 17.6.3.2, we need Osgood plan approval. We believe it's our determination to make that decision, which one we're applying under, and that we then have to go through the plan approval process, either Osgood plan approval or 40A bylaw I-2 site plan approval. We don't believe we're applying for a special permit. We don't believe we're obligated to apply for a special permit. We're being told we're applying for a special permit. Our hearing was advertised as a hearing for a special permit. But we don't want a special permit. We just want plan approval. That's all we want. So that's why we're appealing the decision of the building, or the determination of the building inspector.
So Mike, you're saying that it's an as-of-right allowed use under either, under
Yes.
Osgood and under 40A?
So now there are some technical arguments that we can get into. So for instance, under I-2, under 11B, you allow solar generating facilities. We believe we're an allowed solar generating facility under 11B. There's some discussion about whether or not the electricity has to be consumed on the project. There's nothing in your bylaws requiring the electricity to be consumed on the project. Coincidentally, we actually use twice as much electricity as we're generating, but through the technical aspects of it and the contractual aspects, we technically sell it at the meter and then buy back, even though we're using it on the site. But it's the way that the government captures money, and it's the way the town gets to take advantage of the fact that we're generating electricity and allows them to buy electricity at a discount.
Let's
Okay.
assume you can manufacture it, just for the sake of argument. Where does it say you can distribute it?
What would you do with manufactured electricity? So you can manufacture a bread at Jessica's, but you can't sell it?
I don't know. I mean, distribution seems to me like it could be an issue, too, as it relates to that.
So under industrial, it says you can have a solar generating facility. You're allowed to manufacture, you're allowed to have a solar power generating facility under 11B.
Okay.
That's what we have, a solar power generating facility. It's the only way you can have a solar power generating facility is if you're connected to a net meter and you're connected to the grid. That's mass law. You can't prevent people from generating solar power.
But you're doing more than generating. You're also distributing.
That's what generation of electricity is by its own definition. If you read Chapter 164, Mass General Law, Chapter 164, I mean, that's what the manufacturer of electricity is.
Right?
It's for commercialization. We're generating electricity for commercialization. Now, now under 17.6.3.2, you allow manufacturing. In your definitions of manufacturing in 4.133 under I2, you include as a subcategory light manufacturing. As a subcategory, you include solar. So our argument is that if in a subcategory of manufacturing you include solar, then in a category where you just use the term manufacturing and you didn't choose to modify it in any way, it includes anything you deem to be manufacturing.
But doesn't that go to the ultimate issue in the context of tying an overlay district zone definition to an underlying zoning definition? If you're electing one zone, then you're drawing from the definition.
No, it actually goes to law. Okay, in the bylaws as drafted, if a definition in the bylaws in and of itself can't be interpreted on its own, you have to go to the law. And we've provided you cases on that to talk about that. But a town can't just say we use the term manufacturing, so it obviously must have not included solar. I mean, you have allowed uses in multiple districts. So you allow manufacturing in the Osgood Business Opportunity Zone.
There was a time where that plant ran three shifts a day.
3 shifts, 24/7.
For many, many years.
11,562 employees.
Many, many years.
Manufactured 24/7, 365.
It was always an asset to this community and this town. So I understand the history of it, but in the context of where we are today, so you think because it says manufacturing here and the solar is allowed under I2, that...
Well, again, there's two different arguments, there's two different finding requests here, which is why earlier on I had suggested do we want to take them one at a time. Under I2, solar manufacturing is allowed. It states it in your bylaw.
And you didn't apply under I2 because you were told not to apply.
We were told that we need plan approval, and we were told it has to be under Osgood because the theater came in under Osgood.
So what's been happening at these planning board meetings? Because I haven't been following them. I just know what I read in terms of the authority of the planning board. And while we may disagree in terms of what the planning board's ultimate authority is, it seems to me that they do have the authority to act on this petition. They're just not doing it.
So they identified our petition as an Osgood special permit. We have then since asked to have it withdrawn because we believe that it is faultily advertised because we don't want an Osgood special permit. The planning board has not allowed us to withdraw it. We believe we have the right to withdraw it because the notice is incorrect, and until it has been properly noticed as a matter of law, you can withdraw. It has not been properly noticed. It's been noticed as a special permit. We've asked to withdraw it so that we can make sure that we come back in and it is clearly noticed as a plan approval, not a special permit application, and they are not allowing us.
So what happens at the meetings? What happens when you go to a planning meeting?
Nothing. We've continued them, seeking advice of town council and waiting a determination from the zoning board of appeals.
You show up at the meetings and you're not heard, or you show up and ask for them to be continued?
One time we asked for them to be continued. The second time they asked that it be continued.
And you assented to that?
Yes, we did.
Okay.
Don't know what else to do. One of the things I don't want to do is go through with a hearing, okay, get a decision that's not like you talked about in the last one. I'm going to have a decision over here on an application that's over here that was noticed calling it something.
What happens if you say, no, we don't want you to continue?
Then I'm going to file a repetitive petition because under 40R, you have the right to file repetitive petitions. There's no restriction on repetitive petitions under 40R. So I'll come right back in and file again.
For site plan approval.
For anything.
Have you filed a
Under
subsequent
40R.
petition with them?
Nope.
But you believe you can?
Absolutely.
Okay.
Any application under 40R, the first sentence of,
Now, because we haven't gotten into the merits of what Mr. Leary, because I rudely cut him off in the beginning, and I'm sorry about that, but it's possible that there may be also other, based on whatever it is you're proposing, that there would be other building criteria or any other setbacks or drawings or site plans, or not? I mean, what are the other building materials and methods that would be required?
so I think that's part of the plan approval. I think we've got to go in and we have to satisfy them, whatever it is that they have the right to regulate under plan approval, we've got to go in. We have to do it. We have to show them materials. We have to show them the direction. We have to show them the view. We have to show them the look. We have to show them the parking calculations, how we're going to remove the snow. We have to do everything that we need to do to show them why this isn't a noxious use, why it should be allowed, and what conditions, if any, they choose to impose.
And have you been given the opportunity to do that?
Not yet.
Okay. Well, I think this board would need to hear some of that as it sort of tries to weigh through everything that we've heard so far. But I don't want to, if anybody else wants to ask you questions, I don't want to get in their way at this point. Otherwise, maybe we could let Mr. Mealy make his presentation, and then obviously, you know, the town, because of the nature of the filing, obviously, the town would have an opportunity, just like any other applicant, to present or say what they want to say. We'll just see how far we get tonight. I don't know how far we're going to get tonight.
Well, good evening again. Actually, my intent for tonight, understanding there was going to be quite a bit of discussion about what is a site, what is manufacturing, and developer's choice, had really not intended to get too deep into the project itself, other than to say why is it that we're here tonight? Why is this so important to the town? So I really just want to spend a couple minutes on it, because we do appreciate the town's efforts to try and work with us to figure out how this fits in, because it should fit in. In fact, you may not know it, but this site in 2007 was the home to the second largest solar array in the state. And in 2008, it became the largest solar array in the state on this site. The site's has a vision, and it's a great opportunity for this type of development.
What's a solar array?
That's a great question. First, you don't have to use the word photovoltaic anymore, because nobody can really say that. We just call it PV or just solar.
Couldn't have said that before.
Yeah.
No, we wanted to see how many times you would try.
So a solar array consists of solar panels. A solar panel is about the size of this desk right here. A solar panel takes sunlight, takes photons coming out of the sun, converts them into electricity. And the way that the sort of the legal framework set up in Massachusetts, National Grid, our utility, will allow us to make electrons out of solar power and put them back into the grid using a statute called net metering. With net metering, what physically happens is we'll set up, like you have a meter at your house, we'll set up a meter on the site, and skipping ahead in this case, as you might remember from town meeting, town voted to allow the town manager to enter into negotiations to potentially purchase the energy from this project. So that's how it all kind of fits in. That's the big picture of this discussion. We have the opportunity to capture all those photons that are hitting the parking lot at Osgood Landing and put them into a meter that would feed every municipal meter in this town and provide power for the town for the next 25 years, potentially. So that's sort of the bottom line. Excuse me, the real bottom line for the town, and why town manager finds this project so potentially attractive, if it's an allowable use, is that this is potentially several million dollars in net present value to the town with zero cost. So this is capital equipment that's going to be provided by the property owner that's going to manufacture this electricity. The electricity is going to go into a meter that it's owned by National Grid. The meter might be in the name of the town of North Andover, or whoever chooses to negotiate with us. And that meter becomes a credit to the energy bill. So with the way the contracts might work is it's essentially like a coupon on your energy bill for the next 25 years. So the time sensitivity of it is that this is a limited time offer that the state put together. Solar as a technology has been around for 35 years.
So what is the benefit to the town in the context, because I was at that town meeting
Sure.
where that warrant article got approved. I saw the presentation. How does the town specifically benefit from what you're proposing?
There's three ways the town, there's three direct ways, then a number of indirect ways. The first monetary ways is first there's the, this is taxable property, so there's a potentially a pilot opportunity. So that was one of the town meeting warrant articles, was for the town manager to be able to negotiate a pilot. This is potentially a $15 million project of taxable property.
What is it?
Payment.
In lieu of taxes.
A payment in lieu
In lieu of taxes.
So that's
in
a
lieu
20.
of taxes, not in lieu of the taxes they currently pay, in lieu of a,
This is new capital,
New taxes.
new taxes.
okay.
So there's a 25-year revenue stream that potentially could come out of this project. Part of it is in the form of taxes, because it's taxable property, or potentially a pilot. And the other part is in what's called a net metering credit agreement, where the town potentially could say, well, we'd like to buy the power from your project that you're making at your parking lot and use it to power every school, the fire department, all the municipal buildings. And the town might say, and I'll just use the example Andrew gave Mr. Mailer gave a town meeting, where maybe it's 95 cents on the dollar that the town pays for electricity for the next 25 years through this type of deal.
Not the admissibility, the hearsay. That's a joke. Sorry, go ahead. I'm sorry, go ahead.
Lawyers speak.
We don't usually let hearsay in, but we're going to let it come in.
Okay, but it was an example just provided at town meeting because it was part of another warrant article that was there, and that was an example a town manager had mentioned. So, yeah. So given all that, you're talking about several $100,000s a year of direct benefit to the town for developing a project that's taking up space that's otherwise really underutilized. We're talking about putting solar panels on top of the roof and potentially on top of carports. We're not in any way restricting the ability to do 40R development on the site.
The carports, is that something you're proposing to build?
To Dan's point, the whole point is not doing this in lieu of something else. It's doing it in addition to something else. Unfortunately, I only have one set that I had with me from the last planning board meeting. But if you want to look at these and pass them down.
We'll pass them, we'll
But
put
the
them
theory
in.
would be, you're going to now have covered parking instead of uncovered parking. And above the parking spaces is going to be where the electricity is collected. So you could put it on buildings. To the extent you put it in retail buildings, you could put it on retail buildings, or you would put it in carports, and those carports would have parking underneath them in the back, where it's never going to be utilized, potentially on the ground.
So those blue areas on that board, those are the proposed ports?
This would be a way to put all of the solar arrays, the PV arrays, in the business opportunity zone. And it would put them on carports, it would put them on the roofs of existing structures, and potentially would put some in the ground in the back.
You use the word potential a lot, both of you. Potential income to the town, potential savings. It's not a guarantee.
We have to go through planning, and that's part of
Right,
it.
no, I'm just saying, when it's going to be a potential.
I have to say potential because
I
there's a
understand.
negotiation that'll happen between the town and.
You could always follow through. You could always choose not to go with the town, so now.
There has to be a sponsor. If there's not a sponsor, it doesn't get done. The
But it
sponsor
might
has
not
to
be the town in North Andover.
Correct.
So I just need to make that clear, that there's potential savings.
Can I ask a question, and I don't know the answer, so this is not a...
I'm sure
Does-
you do.
No,
I'm sure you do.
Does it have to
Okay.
be the town or an abutting town, or can it be somewhere?
The contract for purchasing the net metering credits could happen with any town in what's called Northeast Massachusetts, which is pretty much what it sounds like. Any town north of Boston, east of here. Now that being said, there's tons and tons of benefit to building a project and negotiating with a project in your town. Right now, towns are scrambling to find opportunities like this because this is frankly found money. Each town is allowed by statute to build, to negotiate and contract with up to 10 megawatts, of which we're proposing 6 with this project, with projects that could be any town. But if you have the opportunity to contract with a project in your town, well, you have pilot revenue opportunity. And this is, by the way, this is on top of the permit fees that would be paid in year 1 as well.
You keep referring to, why is it taxes in lieu, it's pilot, I know, is payment in lieu of taxes?
Yeah, so pilots are commonly negotiated. I'm going to call a pilot a market condition, and that's because a pilot provides a schedule of tax revenue that both the developer can rely on and the town can rely on, whereas there's been a lot of confusion about how do you properly tax these systems. So the state has put together guidance on this. DOR has put together guidance to support assessors and to help towns understand, well, what's an appropriate schedule for 25 years. So the what I didn't talk about was the indirect benefits, because indirect benefits for this property are huge. Right now, Cummings property, Boston properties, premier properties around Massachusetts, it's beginning, around other parts of the nation, it's been in play for a while, are actively looking for parking structures. I just finished a project. I just finished a carport project for the U.S. government where they couldn't wait to put on a second phase because people actually love parking underneath parking structures. In fact, there's a going rate for that in town. Just as an example, it may be hard to see this, but you've seen it in some of the pictures. Here's a picture of Whole Foods. You know, Whole Foods is an example of the type of 40R development potentially that the town would be looking to attract. And they just came to the conclusion that, one, solar energy makes good financial sense for them. There's a positive return on investment. 2, their customers love packing their groceries, not standing out in the rain, having a cover over their car. It just makes good sense. As Mr. Rosen mentioned earlier, this is attracting the types of businesses and the thinking of our generation. I don't want to underestimate the very first thing I said about this being our generation and the fact that we can power the meters in this town from the parking lot at the old Western Electric building. To me, that's a very profound thing. And that's the big picture.
Okay, thank you. Okay, go ahead.
I'll be back. Excuse me, sorry.
We'll just take a 2-minute break, because I have a few more questions for Attorney. 10. So just a couple of follow-up questions as I digest everything that we've talked about so far. Kind of really more along the lines in terms of your dealings with the planning board. Now, I know we've transitioned through planners. Did you have a planner that you were working with at all, a town planner? Were you working with a town planner?
We were working with Ms. Enright. Previously, Ms. Cheatham came in maybe a month ago or so and has been working with us to try and guide this.
But let's go back to March, leading up to whatever the letter was on. You were working with Ms. Enright then?
We were working with Ms. Enright then.
Oh, okay. All right, so as it relates to your planning board application, I see as of right is a defined term under section 17. I see that plan approval is a defined term, section 31. I see plan approval authority is defined. I see that there's something referencing the PPA regulations. Do you know what the PPA, the plan approval authority regulations are, and if they're codified?
That's codified in 17.
They're codified in 17, or are they in
so.
addition to?
I believe they're in, I'm not aware of anything in addition to, I believe it's in 17.
Okay, so that's something I want to look into, because I want to find out if there's any additional regulations, since they're referenced to be on file, approved by DHCD. They may relate to the residential component and not the business opportunity zone. I don't know. I just want to find out what they are. I think definition 41, as it relates to sub-district, is an interesting component as it relates to the argument of sites. And I don't know what the answer is yet, but, you know, we do have a particular site plan. We do go to great lengths to talk about sub-districts and allowable uses in those districts. And it seems to me that it's even further codified into 17.3.3, those sub-districts and those acreages. And whether or not an argument can be made that they are specific sites, and even if that's relevant, I don't know, but that's something that has sort of come to my attention in the course of your presentation. But what I also noticed under the authority of the Plan Approval Authority, I know you guys don't like to hear this, but I want to ask you anyway. And you may have already addressed this, so forgive me if I'm repetitive. And it talks about the criteria for special permit and other applicable approval by the Plan Approval Authority, which I don't believe in this. Under 17.6.5.9, it talks about the discretion of the PPA in an applicant seeking approval of a development, including both as-of-right uses as well as those uses requiring a special permit or other approval, may combine such applications into a single application. It may combine both hearings into a single decision. And I want to know if that's happened, or if you've asked if that's happened, because I also think that that would be relevant to know what the Plan Approval Authority is going to do with your application. Because you had said earlier that you had wanted to go in as an as-of-right application, but you were forced to do a special permit advertisement. You also said that you believe you can file repetitive petitions, as many as needed. But it says right here in the definition that the application can be combined and heard as one. And is that something that you've addressed with them?
No, that issue's never come up because we are not asking for any other relief. We're not looking for anything else that requires any other approvals, so there would be no reason to ask for a combined application. And in fact, the provision you're pointing to right now is my point, which is you're either as of right or special permit or other approval. You're not both, you're one or the other, unless you're in a situation where you are both, in which case you combine them.
If they would deny you as of right, if they were to say, no, we don't agree, it's as of right, your remedy would still be to come here, right?
If the planning board were to deny us on a plan approval as of right, no, it would be to go to court. It wouldn't be come to zoning board.
So it's interesting to me that the board that has so much discretionary authority with respect to this site, in the context in which this bylaw was drafted, doesn't seem to want to make a decision as it relates to their own bylaw.
I'm not, with all due respect to them, I don't think they don't want to. I think they kind of agree with our assertion that determining what the basic underlying use is first is a decision of the building inspector whose determination can be appealed to this board. I think in their, look, I'd love to say I'm always right and every board's always wrong. At the end of the day, I think they're struggling with what the right section and approval provisions are, which is why they sought the advice of the building inspector. And then we did, a lot of research to put together the arguments why we think that advice was not correct. And I'm not so sure that they're ducking it. I think what they're saying is...
But they haven't given you their own opinion. They just say,
I haven't asked them for their...
We don't know what to do.
Just like earlier, you talked about you can only make a decision based on what you're authorized to make a decision on.
Well, it says manufacturing. So I guess the as-of-right use says manufacturing. So I guess I don't understand, why they simply can't address that. And I think I know the community development director's here and the building inspector's here. I'd love to hear from them. Please. Please.
Eric Kafori, Community and Economic Development Director. Attorney Rosen's correct. What's happened before the planning board, except for one thing, the planning board's never asked anyone for a determination. What had happened was the town, in trying to help out a business that was saying there's severe time constraints here, that if we don't get a nod from planning by an X amount of time, we can't get in line for the tax credits and everything else and the queue, which is a whole nother thing. So they were allowed to make application to the planning board with the understanding that the use determination hadn't yet been made.
Well, they have a right to make application.
Which is right, but with the understanding that the use determination hadn't been made.
Denied. What they asked for was denied.
Well, hang on, yeah, exactly. What was is that once the use determination was made, if the use determination was made in their favor, great, they've met their time issues, and they're already before planning. However, if the use determination has been made, as it has in this case, that it's a use not allowed, then the application would be pulled. The problem is when the use determination, they went simultaneously, one to the building inspector, and the application got filed to planning. So when the building inspector, if you think about it, if they hadn't made the application to planning, they would have gone to the building inspector. The building inspector issued his opinion, which was this is a use not allowed. Therefore, since it's a use not allowed, there was no way to go to planning. This is not supposed to be before planning until the use issue is determined. And that's why there's been an appeal on the use determination.
What use are we talking about? It's not allowed.
Well, the use, when they applied for it, was, if you look at the application,
It says manufacturing is an allowed use.
which,
It says
what the building inspector has determined, and that's one of the issues before you, is that this is not manufacturing. That and so
What is it?
therefore, it is solar generation, and there's a distinction within Massachusetts, within the Commonwealth, and with case law between the two. There's a huge distinction between the two.
Okay, what is that? Has that been submitted to us?
I don't know what's been submitted to you. I mean, what the building
I don't mean
inspector
to
has
put you on the
determined. Yeah.
spot. I want to know what the town's
Oh, the town's position, through the building inspector, is that this is solar generation. It is not solar manufacturing. Therefore, it's not specifically allowed.
Well, how do you manufacture? I mean, how do you?
There's a
There's only one way to make solar, right?
Solar manufacturing is the making of the panel, is the making of the components, the physical things that go into it. Solar generation is what is happening here with those completed manufactured products being used to generate electricity. And there's a distinction clearly between the two. There are actually three elements that the Commonwealth has with regard to solar. They say you have a solar generation facility, a solar manufacturing facility, or a solar research and development facility. North Andover has put in two of those specifically and has rejected one specifically when they did so. They rejected the solar generation. They put in the solar manufacturing and they put in the solar R&D. And they did it under the I-2, and...
After the overlay district was
Correct.
allowed.
They did that in
It was
2010.
allowed after.
in 2010.
knowing that that was still an I-2 underlying district.
But what they said was, in I-2, we already allow manufacturing, we already allow research and development. So therefore, we're allow solar research and development and solar manufacturing to occur. But what we're not adding in is solar generation. And the building inspector has made the determination that this is solar generation.
Can I ask you a question?
Hold on, I'm
Why
gonna...
25 acres?
Wait, I'm not gonna, Mr.
They do
Attorney,
25 acres to put the panels
Attorney
on.
Rosen, I'll let you, just like you had your opportunity, town's gonna have their...
He's making up a law. We're going
Time
to
out.
cite the law just like you want.
You will have an opportunity to redress.
You required that we provide
You're out
a
of order.
specific law, and you have
You're
the
out of
bylaw
order.
in front
You're out of
you.
order.
If
I
the
will
law
let
is
you-
going to be cited,
Attorney
and we
Rosen.
have the law.
You'll have an opportunity to rebut. I promise you, you'll have an opportunity to rebut. I may not do a lot of things right, but I try to run a fair hearing.
I'm sorry.
It's okay. Go ahead.
I don't know what more to add to it. So you're asking why, like, manufacturing is allowed by right. No one's disputing that. We're just saying this isn't manufacturing. This is just solar generation. Totally different use.
So here's what I'm trying to get my hand, I'm trying to understand what the town's real issue is with this project. Because, you know, we've all been around a long time, we've been to a lot of town meetings. I go on the town website, I can understand the substantial investment that the town of North Andover has made with this particular property over the years. It has its own zoning bylaw, all right? I was recently at a town meeting where it was approved to get these credits to the extent that this project is approved. So it seems to me there is a disconnect in town leadership at some level between what certain elements of town leadership wants and what other elements of town leadership wants. And it's all getting thrown on the Board of Appeals lap now to try to make this decision. And I'm not very happy about that.
Well-
So I want to understand really what is the issue with this project?
One, I don't want to get into the debate and.
Well, you're here and you're the community development
But all
director.
the talk, right, but
You're
all
the
the talk.
community development
But
director.
all the talk, Mr. Chairman, all the talk about
You're
the
rewriting my
benefits to the
applications.
town.
You're rewriting the Board of Appeals applications
Who is?
without my
I didn't
permission.
rewrite any application,
Well, yeah.
with all due respect to the chairman.
Well, you know, there was an application that was generated that wasn't approved by ours that I had to correct. And I'm not happy about that either.
Well, let me, can I have a chance
Yeah,
to
you have all
explain
the chance
something
you
on that
want.
to the other board members?
Sure.
We were helping the applicant here in this case. The applicant wanted to make timely appeal of a decision per the zoning bylaws to this board. They went down and was, by the town clerk, and said, you need a form. We don't have a form.
We've always had a form.
There was no, we could not find a form.
Always
So
had
in
to
order
find
to
it. It's
make.
always had to find a form.
We
I've
can't
been on
find a
this board
form.
since
I'm told,
2004.
I'll be, in all honesty, Mr. Chairman, I was told that there hadn't been an appeal of any decision in over 10 years. I don't know if that's true or not.
Nobody asked me.
But let me just say this, we couldn't find the form. So we came up with a form so they can make timely application.
why did nobody
But it
ask
was
me?
it was not to circumvent anything of this board, in all due respect. It was
So-
just to get them an ability to make timely appeal, which they did.
Which was incorrect and needed to be cured.
Oh, well, right now, what I've seen, what was noticed, was that is a request for findings. When what we think is really here, it's a notice for an appeal. And I don't know if there's a distinction between the two, but I seem to think there is. And what's actually was noticed is that the request for findings, when, again, they're really here appealing the decision of the building inspector, which is fine. And we wanted nothing more than to help them get timely appeal. And that's all that was. I wasn't making a unilateral, heavy-handed thing. It was just simply to get a form because they were told they needed a form.
But
And I
what's
was
not-
told we didn't have a form.
But what's not lost on me, and probably not lost on other members of this board, and I know it's getting
I
late,
know, I don't mean to
is
get
that,
into it.
is that the amount of time and effort that the town has invested with this, you know, large income-producing site for the town and this partnership that's been created, and now, you know, in a bylaw that has effectively allowed a planned permit approval authority to streamline a process by design, and then you're stuck with us on this one use issue.
No, for permitted use is correct. And in there's that clause. If it's not expressly stated, it's prohibited.
It's prohibited.
I respect that line.
Okay. so
And I said that from day one with them. And I said, we need to if you want to address it by going to town warrant, we could do so, but these are the issues we think are a problem.
Okay, so the town's position is it's prohibited because it's not expressly stated that the manufacturing of panels is different than photo generation. Okay, and that's what you're basing it on?
Right.
Do you have some case law that you want to supply to us? Has that been filed, other than your letter? Is there anything in the record?
There was case law. What was that case?
Correct. If you want me to get into it, I'll get into it.
You don't have to do
I
it
don't,
now.
what I'd like to do, in all
I
honesty,
just want
this
to know if
seems
it's
to
been
be...
filed yet, for us to read, for the
No.
board members to read.
No, it hasn't.
Okay. But I'm sure that Jerry made his decision based on something.
Sure, we did a lot of research on it.
Okay, I'm sure he did. So I want to know how we supported that, because, you know, the five of us have to,
And gladly
Understand.
supply you that. Do you want that tonight? Do you want that, I don't know what, there's a lot of issues going on,
I'll give you an opportunity to supply it, you know, so the board can make an informed decision. The board has to be able to make
I
an informed
agree with
decision. And that's fine. You know, there's a lot of things that I have to digest personally. I can't speak for anybody else. I'd love for other members of the board to
I'll do whatever the pleasure.
offer their thoughts, you know.
If the board wants a presentation, you know, more, whatever, we'll provide that information. We can come back for the next meeting. You want some
The
tonight,
applicant
that's
is
fine.
effectively, you know, appealing, is aggrieved from the finding.
Yep.
We got something over in planning that seems to be effectively stalled.
Yep.
So, you know, I'd like something that, you know, that we can look at to understand.
Would you like that? Well, I'm asking, you want
Yeah.
that right now? I'll give it to you right now.
If you have it now,
Something.
if you want to submit it, fine. If you're not, we'll take it later. You know, I don't see us being done
So
tonight.
Al, I can give you the case right now if you'd like it. Okay, the case is Dussault versus Kozlowski. Okay, it's D-U-S-E-A-U versus Kozlowski, S-Z-A-W-L-O-W-S-K-I. In that town, they were debating the term alternative energy development, not manufacturing. And alternative energy development is in fact a defined term under the Green Communities Act, okay? So the court ruled that the definition of alternative energy development was a defined term. It didn't argue whether manufacturing was or wasn't a defined term, and it never said that manufacturing wasn't generating electricity, okay? 164, Section 1, okay, is the manufacture and sale of gas and electricity. We are manufacturing electricity. Your bylaw does not use the term alternative energy deployment. It uses manufacturing. If it used the words alternative energy deployment, he would be correct. It doesn't. So the debate there were specific terms, and those terms were in fact defined by a different area of law.
Does that postdate the...
This is in January.
Yep.
This is this
Alternative energy
January,
deployment, when was that defined?
2010. But we're not arguing it's alternative energy deployment. We're arguing the simple term manufacturing.
That term wouldn't have existed when the bylaw was adopted.
No, it would not have existed when the bylaw was developed.
May I add a couple things in
Yeah,
that
please.
case? Footnote. I can go into certain things.
I want to give you an
Right.
opportunity, just like Mr. Rosen had his opportunity.
First of all, the solar manufacture, the solar generation facility, in that case, stated this is not manufacturing, it's solar generation. That was their position. Court said,
That's not our position.
this court said, Hatfield Solar was the name of the company, is correct that the project does not fall within the category of renewable or alternative energy manufacturing facilities. Section 947 defines the term manufacturing. It says here, so they agreed, the court agreed with them. It is not manufacturing, it's solar generation. Now, they did not use the term generation, but in another footnote, the court said, the only difference is the word development instead of generating in the first category. I do not view this difference as significant because development is a synonym for generation. See, in his own footnote, he said this is solar generation. Commonwealth has said three different things.
Give you a chance to rebut. Mr. Rosen, give you a
And,
chance to rebut.
and so I think there's a lot more to this than simply saying, well, it is, and I'm happy we can come back and throw legal opinions or whatever. And the members of this board need, I think, in due respect, a lot of opportunity to digest all this information, but it's not as cut and dry. There are a lot of things. We can debate site. I can do that now or not. I don't want to. But I can tell you, they use the term site in their own application for this.
Okay.
Countless times. And when we do a site plan review, it's based on property lines. Site is clearly defined. Even in 17, there is a point where they say lot coverage. If you look at the definition of lot coverage, which I'm trying to find my note on that. Trying to find that.
Number 25, page 5.
If I'm not mistaken,
The gross floor area for a principal and accessory structure is permitted on a site.
on a site. And so they're saying the buildings and every structure on that lot, on that site, is lot coverage.
Okay.
Applying, you can very clearly read lot and site to be synonymous to each other.
I don't think site is...
May I now?
When he's done, I will, Mr. Rosen, Attorney Rosen, forgive me, I will address you, and when he's done, you can come up and rebut. And it's getting kind of late, so I think we're going to need time, I think we're going to need a continuance for another hearing, honestly, if that's something you're willing to assent to. And, so, Mr. Kafori, is there any, did you have more that you wanted to present tonight, or do you want to? I'll give you an opportunity, I'm sure the board will give you an opportunity to file.
Yeah.
We'll
I think,
continue
in
the
all
hearing.
honesty, it is getting late, and I get that, and I think these are complicated matters, and certainly would like to know exactly what the board members want us to address, and we will do that. I'll get that information to you. But I'm also here to answer any question any member may have.
Does anybody have any questions for Mr. Kafori at the moment?
I do.
Can I just repot a couple of points?
No,
Al,
no,
as a
no.
matter of procedure, I was in the middle of my presentation. You asked him to come up and answer a quick question for you.
As a
My
matter of procedure, I'm
presentation
still
hadn't
running this
ended
meeting,
yet.
Mr. Rosen. So I'm going to ask you to sit down, we're going to address him, then you can come back, okay? Just, hold on. What are you over here? Yeah, go ahead.
I have a question. And I understand it's on your letterhead, you're part of William Hale.
No, I'm not.
Who is
Wait a
William
second,
Hale?
wait. Your question's for Mr. Kafori or for Mr. Rosen?
For Mr. Rosen.
Okay, hold on. Are you done?
For now, yeah, again,
Okay.
I'll present all the information you want, but
But Al, before we close this part, I just want to make sure, because I have no shortage of questions
Right.
for
That's why I
Mr.
was-
Kafori
that's why I was
and
asking.
Mr. Rosen, but I want to make sure that we are in some way organized, that way we can be complete with our questions.
So we asked Mr. Rosen a series of questions while he was up.
Yep.
And Mr. Rosen wants to come back up, but since Mr. Kafori is here now, let's ask Mr. Kafori his questions. When we've exhausted asking Mr. Kafori questions, we will then ask Mr. Rosen. He can address anything else he wants to address. And let's just do it that way, in an orderly fashion, so people aren't jumping up, interrupting one another. I just want to give everybody a chance to talk.
The reservation that I have with that is, Mr. Rosen has had no shortage of time, and I know that he's not done. The questions that I have and the concerns that I have for the town is, it's not, what's your favorite color kind of thing. We're going to be here a while when I start asking questions. So I'm of the mind that I'd rather not get into it with Mr. Kafori unless we have time to achieve it for not just me, but for everybody.
Well, I
So
think-
it just doesn't make sense to ask Mr. Rosen to come up, kind of complete the presentation and call it a night, and then bring up the town at the continued time.
I think that makes sense if you want, because I suspect the board would be inclined to want to continue this hearing. And, we'd like the applicant to agree to that. So if that's acceptable to the board, we'll present it to them. And is everybody okay with that approach? Okay.
Do you have case law in here? Do you have the law that you're citing? Is it in my
I
package?
don't know if
It's
it's
in
in,
the package that I submitted yesterday.
Is it the same one that you were
yeah,
referring
the
to?
case he cited, right.
Okay.
Correct.
Yeah, I didn't.
What is the name of that?
Just so, it's DUSEAU versus says Lowski, it's SCAWLOWSKI, and it was a slip opinion issued in January of 2015. If you'd like, I can get a full copy of it to Angela and have her circulate it.
Whatever you folks want us to read, you file with Angela, and she'll circulate it to us. All right, and that's usually the way it gets done. All right? So, all right, so let's let Mr. Rosen come up and state his points and questions for Mr. Rosen, and then maybe 10 minutes worth, and then, is 10 minutes enough time for you, sir?
Not even close.
But
But I
tonight-
do 10 minutes to rebut a couple of false statements that were just made.
It's going to take you 10 minutes to rebut, really?
Yes, it is.
Let's see how you do.
Okay, so.
I have faith that you can do it in 5.
First and foremost, when Mr. Kafoury speaks about the terms generation and deployment, and the reason that the court footnoted those terms in the case, it's because those terms specifically exist in that local town's zoning ordinance. So he directed them to their ordinance and said, you can't argue that it's manufacturing when you have defined terms already. The terms don't exist in North Andover's bylaws. If they did, Mr. Kafoury might be correct, but they don't. The terms in your bylaws are manufacturing. Okay? The terms in your bylaws specifically talk about, in order to have a solar manufacturing facility, you need 25 acres. You don't need 25 acres to make a panel. You need 25 acres to deploy arrays to manufacture electricity.
And that's my bylaw.
That is your bylaw
That's for the...
for the I-2 4.133. So if we're going to make arguments, let's make genuine arguments here. You have a bylaw that specifically requires 25 acres to manufacture solar electricity.
I've read...
Okay, no,
Wait, hold on. I'm going to treat you, Mr. Kafoury, the same way I treat Attorney Rosen. You're going to get an opportunity to...
I didn't make any aspersions necessarily on his arguments were genuine or
I'm
ingenuine.
just trying to run a public hearing. I'm just trying to run a public hearing. You'll get your chance again.
Yeah.
Really.
second point I want to make, the word site is absolutely used in the application, okay? The applicant will lease site from owner. They're not leasing the whole property, they're leasing a site to deploy solar panels. That's how the applicant used the word site. So again, let's put it in its context. It was used to describe the lease pad, the lease area that was going to be leased by the property owner to the applicant. Okay. Third, and most importantly, if we're going to keep going back to this, we're I-2. We're not Osgood. If the rule was we had to select and we had to define, and site is the whole lot, then the lot, the site, is I-2, and the planning board made an error granting a special permit to the community theater because we leased 463,000 feet of space after Osgood was adopted for I-2 uses under the I-2 bylaw. To come back now and argue that the entire parcel is Osgood, and by the way, we've leased subsequent to that. It's only solar.
And those were applications, those, when you say you
We
leased...
go get building permits.
You got a
So
building permit.
So the building inspector would have to tell us, this permit is invalid because you're in the Osgood district and you need to go in front of the Osgood board. We leased retail space, which is allowed under I-2, but not allowed under Osgood. We would have needed a special permit, but we got those building permit applications. Every single use, 700,000 square feet of use, has been permitted under I-2, with the exception of one facility in the middle. Not at the very last thing we've done, but something we did about a year and a half ago. If site is lot, then we're I-2. I would like the time, and I understand the hour and the time. I would like to go through each of the 5 points and specifically explain why I think that the findings that we're asking for should be granted. If you would rather, I will save it for a closing at the end and try and keep this thing moving on.
Yes, my board.
Okay?
Is that fair? Is that fair?
Yep.
Because everyone has to
Yeah,
be fresh.
no, I totally understand.
You want
I just
to-
didn't want to lose the rebuttal points
No, I don't want you
tonight
to lose
while
them.
we were, thank you.
I don't want you to lose them either. Do you want to
I
hear?
don't want to save the list of 5 finding arguments for a mere closing. I want to be able to have some,
Do you want to hear him now, or at the next meeting?
I'm going to be a while. If he does his 5, then I'm going to be a while asking questions, so I don't know that it's appropriate to be doing that now, or efficient or effective to be doing that at this hour.
Yeah. Those are the points that you submitted to us that we can read, right?
Yes.
Okay. So, let me ask the board. You guys inclined to want to continue this to our next regular meeting?
Absolutely.
Yes.
Yes. What about you, Rick?
I say continue it.
Oh, good for you.
I haven't heard of it.
Is the applicant under timing restraints?
I'm going to ask, are you inclined to assent to a continuance where you sign our time waiver form so that we may have the opportunity to review the materials and continue with the presentation at our next meeting?
Do you know when the next meeting is?
Of course we do. Angela? August the 11th.
Is there a way to do an interim meeting?
No. There isn't. That's where we are.
I don't,
I'm going to need 2 minutes to talk to my client.
Take 2 minutes.
Thank you.
Sure.
I don't have sidewalk, I don't have a line.
All right, we'll go back on the record at 10:20.
Could I ask a couple of quick questions?
Of
As the format of your form for a continuation, is it for an indefinite period? Is it to a date certain? How does that work?
It's to a date certain to our next regular meeting. So we have a time waiver form, Angela has it with her. It's by motion, and your assent.
And all we're doing is essentially, whatever the time periods are, we're agreeing to grant, Jesus.
You're granting a time waiver of the dates with which the board would act. So we're going to continue this hearing. We'll let everybody, say their piece at the next meeting. Much like you've been doing with the planning board, in terms of the
So
continuances.
my problem is I got to go back to them now and leapfrog and do the exact same thing, and we're trying to keep track, because we gave them a continuation for the exact number of days that they put up our hearing in front of them to the next hearing.
And we can certainly send them a communication for their record, indicating that we've assented to the time waiver here, that the board is still taking information and deliberating in the public. We're not closing the public hearing, we're just continuing it. It's a standard practice for us. We do it with many hearings.
Second question.
Yes, sir.
After August 11th, when is the next meeting?
I couldn't answer that without Angela,
No, I understand.
although I'm sure they're posted at the
The
town
second Tuesday of
clerk's
September.
What is the
website.
Second Tuesday.
Year in
of-
advance.
Once a month?
Yes, once a month, usually the
September
second
what?
Tuesday of the
September 8th. It is, traditionally the second Tuesday of the month. We run into the problems in May and June, but,
town meeting.
yeah.
Okay.
So that would be the next meeting.
And is there any way, again, I expect that it's going to take some time. I don't want to take up an entire agenda. I don't want to keep everybody here late, but I also would prefer not to continue it again. Is there a way to either start early that night, agree that we would have a later end, so that I can try and get it all done for everybody in one night, and we can try and get through it?
Here's the thing. I'm not gonna treat this hearing any differently than I would any other hearing. Okay, so we would be continuing this to our next regular meeting that would start at 7:30. I don't know what the docket would be, if it's a heavy docket or a light docket, because of the filing deadlines that people have to comport with for applications. But, certainly, you'll get whatever time you need to complete your presentation that night. Clearly, we want to hear it and complete it as well.
Angela,
It's in everybody's best interest to get it done.
do you know what you have on the docket for August 11th?
Okay, so far.
Yeah, so,
Not to say we're not going to get some.
but
No, I'm
But,
trying to be cognizant of everybody's time as well.
But so, as you saw tonight, we can take things out of order based on how we assess they're going to go. And, and I do manage the agenda and I do manage the docket. It's one of the fun things I get to do.
One last
So-
question.
Yeah.
Will the 5 of you who will have the ability to vote be here, or would anyone be on vacation that week? That was the one
That's a
thing I
fair-
actually checked when I went out in the hallway.
That's a fair question. So that goes to what we started in the beginning of the meeting. Mr. Byers will be here.
Correct.
So I don't know if
I won't
anyone,
be on vacation, to answer your question.
Thank you, I appreciate it.
I don't know if I'm going to be on vacation or not, but I can tell you, even if I am, I have a history of making it back to meetings.
Thank you.
I'm anticipating being here.
Thank you.
But I have to say,
I don't miss.
you can't take that in the context of a promise.
Absolute-
Our intent is to come to every meeting.
Right.
He was just asking, do we know we're going to be on vacation?
Right,
That's all he was
if
asking.
somebody knew that 2 of you were going to be on vacation that week, like I happen to be leaving on vacation that Friday,
Yeah.
I figured I would ask the question. It doesn't make sense to continue it to August 11th, sign a piece of paper, come up on August 11th, and only have 3 voting board members here.
I should be here as well.
Okay.
You need 5, so you need 4 votes
Correct.
to overturn.
Okay.
And that's my understanding of it. So, even if one of us wasn't here, you'd still have 5, right?
Can Denny vote?
Absolutely.
Okay, so because the 6 of you will be here and are voting members if somebody is absent. Okay, I thought, for some reason, as I understood it at the beginning, only 5 of the 7 of you were going to be continuing on. Okay,
Yes, so we're a 5-person board with 3 alternates.
oh, okay, you said, okay. I thought you were 7 with 2 alternates, and I thought you were down to, okay, got ya,
We have
we're
one
good.
We have one
Okay.
alternate that's moved up, and then we'll have 2.
I'll be the leftover.
two other. So then, you know,
You're a spare. You are a spare.
A survivor.
quite honestly, you couldn't possibly be as
We're
long
good.
of an alternate as Ellen was
Yeah,
for a number
20
of
years,
years, for
yeah.
20 years. So
All set. You need us to send something tonight, or you want Angela to send us something tomorrow?
if you're going to assent on the record, I'd assume you sign it tonight. We'll take a motion and
I-
move to continue.
I don't have a copy of that case law. I only have the cited. You said you were going to send Angela.
I'm going to send the full case.
Yes.
In the package that I gave you on the second to last page, the relevant section where they talk about,
I flipped them around, so.
Okay,
yeah, so
you
then
want me to
I'll
show
know.
you?
No,
Okay.
I like the whole case, too.
okay, yeah.
All right, so with that being, I'll hear a motion to continue this to the next regular meeting.
So moved.
I'll make a motion to continue the hearing till August, whatever the appropriate date is. what-
August the 11th.
August the 11th.
I'll
Okay,
second that, Mr. Chair.
motion is second.
Alan made the
Motion by Mr.
motion.
Kuchar, second by Mr. Koch. All in favor of continuing?
Aye.
It's unanimously continued.
Thank you, I'm sorry I took up so much time tonight.
Okay, thank you, Attorney Rosen. Thank you. And then, thank you, Mr. Larry.
Some of the time,
All
I
right.
thought I was with it.
And then last on the agenda, we had communications from Chapa, and I will hear a motion to adjourn.
Motion to adjourn, Mr. Chair.
Is there a second?
I'll second.
All in favor?